karibu this afternoon. So those are the few of us, and but the rest will join us. We had almost full house in the morning. So karibu, you can introduce yourself, Junet, shortly, briefly.
Thank you, Chair and the co-chair. Chair, as you said, my name is Honorable Junet Mohammed. I'm here also under the capacity of being one of the promoters of the BBI bill. With me here is also Honorable Dennis Owero, who is also a promoter of the bill. The bill has 4 promoters, Honorable Owero, myself, Honorable Janet Ongera, and Madam Sarah Kilemi Mwiria. But we are representing the other 2 here today. With us also is our legal experts who are working with us. We are here. On my left is Advocate Tom Masharia, and Professor Sihanya is also here. We also have people from the Secretariat who have worked on this document. We have Kai Kai, and we have also Moffat. I think I've introduced all our team. Then we have our legal expert also, and gender expert, Madam Priscilla Nyokabi, also is with us here. So, Chair, with your permission, I don't know whether we proceed. We can proceed.
The memorandum.
I think we submitted a memorandum, yes.
Oh, you give it to us.
Yeah, we can give you copies also.
Give it to us, and then briefly, I think, I don't really want to limit you unduly, but if you can compress and do it within 15 minutes, the better.
Thank you, Chair. Mine actually is very brief. Mine is just to introduce the team that we're working together, and also to share with the committee our case, why we feel that this bill needs to go through through Parliament. And I will give time to our experts and my co-promoter to present the case to the committee, to the Joint Committee of the National Assembly and the Senate. So I want to invite with your permission, Honorable Dennis Owero, to say a few things, then we can invite the experts to present our case.
Thank you. Thank you, Junet, the co-chairs. Thank you for giving us the audience. We had sent our memorandum earlier of what the Secretariat wanted to share with your committee, joint committee. And I'm going to give the synopsis of the memorandum, and then I will now invite in our experts to expound further. And as you're aware, in 2018 March, His Excellency the President and our opposition leader, Raila Odinga, shook hands with an intention of bringing together this country. As you're aware, uniting Kenya and improving is a continuous exercise that is perpetual, and that is what brought together the 2 leaders for the unity of this country. Raila Odinga and Uhuru Kenyatta, after they shook hands, that was in 2018, it created an opportunity to unite this country. And then, in order to strengthen the rule of law, unite Kenyans, and deepen the constitutionalism, and launch a comprehensive reform process, and consolidate that momentous opportunity that came with the handshake. A steering committee on the implementation of the task force of BBI, that is BBI, to a united Kenya report was established by H.E. Uhuru Kenyatta by a Gazette Notice number 264 on 3rd of January 2010. The terms of reference of the committee are specified in the Gazette were to conduct validation of the task force report and propose administrative, policy, statutory, or constitutional changes that may be necessary for the implementation of the recommendation contained in the task force report. The said task force report made recommendation to the government based on the response of Kenyans to the 9-point agenda contained in the joint communique following the historic handshake between the two leaders on 9th March 2018. On 10th January 2020, HE President Uhuru Kenyatta appointed a steering committee through the Kenya Gazette Notice 264 with the following terms of reference. A, conduct validation of the task force report on BBI to a united Kenya through consultation with the citizens, civil society, faith-based organization, cultural leaders, and private sector, and of course, experts. B, propose administrative, policy, statutory, or constitutional changes that may be necessary for the implementation of the recommendations contained in the task force report, taking into account any relevant contributions made for the validation for that period. Among the proposed constitutional reform, that is what we have been tackling. And I'm also going to give later some of our technical committee to take us through some of the task recommendations. Among the report, the bill, for the detailed background information and recommendation and reserved approval of the Bill of Parliament, the Secretariat referred to the honorable members, with your permission, to the Joint Committee, 1, the report of the Presidential Task Force on Building Bridges to Unity Advisory, October 2019. I also want to refer your committee to the report of the Steering Committee on the implementation of the Building Bridges to United Kenya Task Force report. And finally, I also want to refer your committee, joint committees, to the Memorandum of Objects and Reasons contained at pages 29 of the document we have submitted to 42 of the Constitution of Kenya Amendment Bill 2020. Following analysis of the view presented and thereafter validation that was done by Kenyans, the steering committee proposed the following amendment. Chair, the first amendment to the Constitution was Chapter 2 of the Constitution on formative aspect of the Republic to address the regional integration, cohesion, shared prosperity, and centrality of the economy, which I will later give to my colleague, Nyokavi, to expound further at a later moment. Number 2, amendment is Chapter 3 on citizenship to strengthen the national ethos by outlining the responsibility of citizen, which I will also give to Nyokavi. As you are aware, that dwells much more on issues of utu, clause on humanity, and character of a Kenyan. As you are aware, like if you go to Tanzania, there's what Tanzanians are known for, Ugandans, and I will leave that to be expounded further by our expert, Nyokavi Pirisila. The third amendment is Chapter 4 on the Bill of Rights, to provide a constitutional underpinning for the privacy of citizen personal data as emerging areas of human right owing to significant technological development in this area, which will also be tackled by Nyokavi. And finally, Chapter 4 for Nyokavi to expand will be on Chapter 6 on leadership and integrity to intensify the fight against corruption by strengthening the relevant institution to enable us to be able to improve on the fight against corruption, which is very important for our country, which again I'll leave to Pirisira Nyokabi to expound further. Number 5 was amendment on Chapter 7 on representation of the people to resolve the issues of divisive elections arising from the electoral processes. This, I think, is a very emotive issue which we looked at, and again I will request my colleague Shihanya to comment on that quickly, of course assisted by Tom Masharia on the amendment on Chapter 7 on representation of the people. Again, number 6, an amendment on Chapter 8 on legislature to undertake the following models of parliamentary system by bringing the government back into the House, including the Prime Minister, the Deputy Prime Minister, Cabinet Ministers, Attorney General, and the Leader of Opposition, being the person who is running up in a presidential elections. So that one, I'll again invite Ben to continue as he tackles the amendment number 5, together with amendment number 6 on the legislature. Amendment number 7 that we are recommending in the bill is on the executive by expanding the national executive in order to promote greater inclusivity and mitigate against the drawback of winner takes it all, which I will request Shihanya, Professor, to comment a bit on. Mr. Chair, we also recommended in the bill an amendment on Chapter 10 on the judiciary to enhance judicial accountability to the people of Kenya, which I will invite Tom Masharia to comment on the issues of ombudsman and the judiciary and the Judicial Service Commission. As you're aware, there's some work that needed to be done there. Chapter 11, number 9 is Chapter 11 on the devolved governments by taking the following changes that I think will also be tackled by Tom Masharia. Is very, very keen on issues of devolved units and devolution. So I'll invite Tom. And finally, number 10, we've recommended an amendment to Chapter 12 on public finance to streamline public finance, principles and processes to promote efficiency and ensure expenditures are directed to maximize utility, which I will request our expert, Tom Masharia, to expound briefly. And finally, on number 11, Chair, there is an amendment on Chapter 13, 14, and 15 amendments to ensure that public service, national security agencies, commissions, and independent offices are not only strengthened, but also accountable to the people of Kenya, and we have internal accountability systems and transparency, and also some level of separation of power of appointing and promotion, interdiction, and censure. So with those few remarks, Mr. Chair, with your permission, we are going to take a very short time. We are planning to do under 20 to 25 minutes. And with your permission, I would like to invite Pirisira Nyokabi to do a brief presentation, and then we can proceed from there. Thank you.
Okay, you may proceed, Pirisira Nyokabi.
Thank you. Thank you very much, Chairperson. I will be very, very fast so that we take as little time as possible. Referring the committee to Clause 10A, which is the first amendment in this bill on the regional integration. There is development in the region, East African region, but also the continent, around integration. And many constitutions in the Commonwealth have these clauses. So we don't want in future, when we are doing regional integration, to have problems of our own laws. So just have the clause allows you to go into regional integration matters as far as regional developments are concerned. 11A is a new clause on the economy The country has concentrated so much on sharing the cake. Not as much concentration has gone to baking the cake. So this is the first time that the country is going to concentrate on baking the cake. Investment, trade, agriculture, pastoralism, blue economy, digital economy, all of those matters are addressed, and Parliament is required to pass many, many laws that then implement the baking of the cake. Economy and shared prosperity. Again, the term shared prosperity and equitable opportunity for all Kenyans finds space in the constitutional document with that clause 11A. 18A is the next clause. On the 9-point agenda, the questions of national ethos and responsibilities were raised. The African Union Convention has a balance of responsibilities and rights. It is true we have a very good Bill of Rights, but we also need now not just to have the Bill of Rights, but also to have the responsibilities of a citizen, returning us to factory settings as far as national ethos are concerned. Respect for private property, respect for public property, a lot of those matters of cohesion, how we live together as Kenyans. This is our moral code as a country. Borrowed heavily from the African Convention on Human and People's Rights, but then also the Nakuru Pastors Fellowship really made a lot of input, and many Kenyans addressed the questions of being comfortable in our own African skin, so African family, and you will see the questions there addressed around cohesion in the responsibilities clause. Chapter 4 on the Bill of Rights, just a slight amendment on digital development, protection of personal data. That's the only introduction to the Bill of Rights. There is no other touch on the Bill of Rights, and that is why we even find the responsibilities clause is not put in the Bill of Rights. It is put in the citizenship chapter as we try to build the national character of a Kenyan, similar to what other countries have done. Here in Kenya, we have 45 communities. Tanzania has 120. Our ethnicity is much higher than what they have in countries like Cameroon that have 250 sub-tribes living together. At 45 here in Africa, we are actually among the lowest in the region. Nigeria has over 200. So our 45 communities can have a shared moral code in the responsibility clause that you see there. On the digital development, just the personal data to protect the data laws, and now the data commissioner that we already have in the country. On leadership and integrity, the expeditious conduct of investigation, prosecution, and trial. Our corruption cases are taking too long in the courts, 10 years, 20 years, 15 years. It is time that timeline was capped, and this constitutional basis allows the corruption laws to be amended trial conducted on a day-to-day basis. We actually need the corruption cases to be trial on day-to-day basis so that the cases can be wound up. And it is also wrong for a country to believe that everybody is corrupt. It cannot be true that everybody is corrupt. We really just must be able to deal with those that are corrupt. The increased resources to counties are going to require tougher corruption laws. The strengthening of the institutions, that will come later with Tom. And let me just end with the 2/3 point, because my friend Ben is going to do more of the representation of the people. But it is true that as we were building bridges, the women were also very keen that the gender bridge is built. Building the gender bridge meant that pending matters, like the 2/3 gender rule, would then be implemented in this opportunity. That part of implementing the Constitution of Kenya 2010 is then amending it so that areas that are pending, like the 2/3, can then be dealt with. But we will come back with the Common Women Agenda and just spend a little bit more time on the 2/3 gender debate. But just understand that as promoters of the bill and as the technical team that worked on the bill, there was no way of leaving out pending matters like the 2/3 gender matter at a time when the constitutional amendment bill is being amended, and at a time when the Constitution of Kenya 2010 is being reviewed, as it were. Thank you very much. Back to you, Dennis.
Thank you very much. That was a good presentation, and with your permission, Chair, I will invite the Professor to comment, and maybe as he comments on our memorandum, he can comment on the equity of votes at the National Assembly, equity of counties. He can also comment on these other things, like the powers of vetting for the Senate. Professor.
Thank you so much, Chair, Co-Chair of Joint Committees, and Honorable Waweru. So, Chapter 7 focuses on representation of the people, and it works on the basis of the principles developed in Articles 81, as well as 90, 97, 98, 177. Basically, 97 is talking about National Assembly, 98 is about Senate, 177 is about county assemblies. And the principle there is about the equality of the vote, that every vote also needs to count. And when you go to the National Assembly, the main principle there, of course, is the equality of the vote. But when you come to Senate, the main principle is that of equality of the counties. And as a result, there is need for greater transparency and fairness in representation across the country, with population and, of course, geographical expanse also being taken into account, among other factors. Promoting electoral competition based on values in the Constitution, and ensuring that the electoral processes are fair, transparent, verifiable, accountable. Those are some of the key principles which then are developed further as you look at Article 87, which Honorable Nyakabi has mentioned, and she asked that I talk a little more about it. The amendment to Article 87 is one of the most crucial in this bill, partly because we have so far failed as a country to implement, for instance, the 1/3 or 2/3. I always say at least 1/3, and some people say not more than 2/3. However you would look at it, at least 2/3, 1/3 of every gender. We have so far not been able to, in spite of Parliament making all the efforts they could in terms of amendment. We've really failed, to a point that we will recall that the Chief Justice, former Chief Justice, had to issue an advisory. So this cannot be resolved without an amendment to the Constitution, so that we deal with this issue. And Article 87 then will also bring in the issue, apart from the gender, at least 1/3, it will also bring in the question of youth and the question of persons with disability, so that they have space in our representative organs. The same issue there is Senate then is a 47-47, where you achieve parity between the genders. And of course, there was no fundamental problem in representation in terms of the county assemblies. Chair, in item 6, which is on the legislature, the main change here is that, as Honorable Waweru mentioned, now it's bringing in the members of the executive. You will have an executive, what I've been calling the executive legislative power structure, so that the Prime Minister, Deputy Prime Ministers, Cabinet Ministers, AG, and Leader of Opposition, you will see that, especially if you exclude Leader of the Opposition, the rest actually belong to the executive in many countries, and even in Kenya. And under 2010, we adopted almost a pure presidential system. Briefly, Chair, on that, Kenya has experimented with all the models that are out there on the legislature. We started off with the Westminster export model, whereby the executive was fully inside the legislature. We modified it much later, and the president didn't need to sit in as head of government, head of state. The president did not need to always sit and answer questions in the House. Much later in 2010, we said that let the top of the executive, the president, the deputy president, not sit in our houses, and the cabinet ministers as well, or cabinet secretaries as we now call them. And we've realized, Kenyans realized in BBI Report 1 as well as the Validation Report 2, that those models that came from the UK, our former colonial masters, or they came from the US, have not worked for us. So in summary, Kenyans are saying, let us do a hybrid model of presidential and parliamentary system whereby the top of the executive will be in the House. In BBI, we used to call it autochthony, autochthonous, homegrown, home-based, our own historical experience being brought to bear. Chapter 9, Mr. Chairman, is about the executive. And again, you will see that there's an executive legislative power structure. But here, let me just focus on the executive, whereby, of course, there is no change, fundamental change on the presidency, on the president or on the deputy president, president or deputy president. The idea, but there is reintroduction of a prime minister, and for the avoidance of doubt, we had a prime minister at independence, Prime Minister Jomo Kenyatta. We had a prime minister in 2008, 2013, Prime Minister Raila Odinga. So we have had experience with the prime minister, and Kenyans said that bring that office back. And as you bring back the prime minister, and in a different model, of course, with the deputy prime ministers, etc., the idea that Kenyans said in the BBI reports 1 and 2 is that please avoid two things. One, please avoid imperial president. And number two, avoid the idea that we create two centers, two antagonistic centers of power. So those are the models that Mr. Tom Macharia and all of us will remember that we were working with on the advice of Kenyans. Avoid imperial president, avoid two centers of power, but let them share power. And you will see that the BBI, the 2010 Amendment Bill proposes that there be a prime minister, for example, who will chair cabinet committees. And this is not a super CS, not at all. This is a prime minister who is the leader of a party, which has majority in the House, or the leader of a coalition of parties that is majority in the House. So they don't come from just mere appointment in one morning. Secondly, this is also a prime minister who has constitutional authority, whose powers are given by the people, the constitution, and statute. Of course, some powers can also be given by the president. So these are some of the issues that are important in protecting Kenya's future. Shared prosperity, inclusivity, including winner doesn't take it all. You will see, for example, in the legislature, when you are talking about party list, a party will earn those seats based on the votes that it earned, not on the seats that it won. What is received, which is a very major change. Lastly, as I hand over to my colleague, who was the co-chair of the team of experts with me, Mr. Tom Macharia, who was a co-chair with me on the team of experts, the last point I would make is that there is also Article 230 on SRC issues, and SRC has a very major role to make sure that we rationalize and harmonize remuneration and pay in public service. And this will help, the public service will help also give leadership in the private sector, so that all of us have shared productivity, which Honorable Nyakabi talked about, and shared prosperity and inclusivity in the economy. Mr. Tom Macharia, Advocate Tom Macharia, please.
Thank you very much, honorable members of the Senate and of the National Assembly. I'll speak briefly on the question of representation, and in particular about the question of increase of constituencies in the bill. Allow me to speak straight to the question of the principles that were involved. As I think you know, the bill proposes to increase the number of constituencies in Kenya from 290 to 360. That is number one. Number two, there was a question, and I think my colleague and learned friend Priscilla Nyokafi said she would speak to, which is the question of achieving the 2/3 gender rule. Allow me to speak to the first question. When the steering committee and the task force before it started to look into this question, they reviewed a lot of material. Thank you very much. They reviewed quite a bit of material, and as Honorable Dennis Waweru had said earlier, a lot of it is set out in the annex to the BBI report. But as regards the boundary delimitation, these were the principles that were involved and that guided that process. Now, as members of these honorable houses will be aware, and of the Joint Committee will be aware, in 2012, following the promulgation of the Constitution of Kenya 2010, the IEBC was mandated to delimit boundaries and came up with a report which was submitted to both houses, these houses of Parliament, which is called the Revised Preliminary Report of the Proposed Boundaries of Constituencies and Wards. That was one of the resource materials that was looked into, and I'll say a bit more about that as we go along. So those observations from the last delimitation process, that's number one. Number two, there were principles that arose from a court case that was filed. Actually, there were several cases that were filed at that time. There was one that followed the boundaries delimitation process itself. And there was one, a case known as John Kimanthi Maingi versus Andrew Ligale and others, that was filed and determined in the course of the process. The other one were principles that were identified by the IBC at the time, and which in the report I've just referred you to, which were the nexus between resources, or at least in the minds of Kenyans, the nexus between resources and boundary delimitation. That was the other one. The other one, of course, was the fact that, as I think the promoters here have said earlier, the BBI process itself was triggered, I should say, by a disputed election in 2017. And so the area of consensus building and some of the issues that arose or the lessons learned from that process were one of the other issues that was then used to determine this. The other one, of course, was that the IBC itself has actually begun the process of delimitation, and I think you may recall there was a statement they issued in early January 2020. And then, of course, under the report that I've just referred you to, the IBC had indicated in their 2012 report that even as they began the process, just like BBI has done, they were guided by law and required to be guided by a report prepared by the IIBRC at the time, the Interim Independent Boundaries Review Commission, and the Justice and Legal Affairs Committee of Parliament of this house itself was one of the guiding documents they were required by law to follow. And so they too were guided just as BBI seeks through the sovereign will of the people of Kenya to guide them to do. On top of that, you will recall in 2012 that we began with 210 constituencies. Those through the process, and there's a lot of mathematics and a lot of material set up in that report, and I can't get into all of it now, and you'll be able to see that later. That number was then added to become the number we now know to be 290. But of course, apart from the 290, you have the 12 nominated, and you have the 47 women rep members. So at least in the National Assembly, we are talking about 349. And so the average number of people represented in those, by those 349 people is 136,000, which became the population quota that we used for purposes of determining whether, as I think some of my colleagues here have said, the principle in Article 89, Sub-Article 7 had been complied with. And that's also in the report here that IBC had prepared. And I think, of course, I should add here that IBC themselves did submit a memorandum to BBI when the process began. On top of that, one of the other principles taken into account was that in 2012, and they're listed here, they're also in the report identified 27 protected constituencies in Kenya, and they're listed there where all of them are. And of course, the point was that those constituencies did not meet the population quota that Article 89 prescribes. Apart from those 27, you have another group of about 8, which in the near future, with 18,000, 20,000, or 30,000 people, are nowhere near meeting the population quota and are unlikely to do so. So these were all the principles that were then applied to the process of determining. And then I think I should add as well, on top of that, in 2016, the Auditor General at the time, Mr. Uko, I believe, audited the impact, the socio-economic impact of implementing the Constitution of Kenya 2010. Among the things he did was to examine a question that is sometimes, I think, a bit over-tortured, and that also came to the task force and subsequently to the steering committee, is whether Kenyans are overrepresented. He actually examined that question. He did a lot of data. He went around the world. He took the numbers from many other countries, and you can be able, I believe the report was actually submitted to Parliament as well. Among the things noted there, and it's been noted elsewhere by other experts apart from the group represented here, was that the International Parliamentary Union cites a number of 123,000 people as the average number of people an MP should represent in the category Kenya is put under by the IPU. It may interest you to also know that in 2010, the average number of people represented by MP was 133,138. So that's the number, 135,000, that was then used to determine whether there's adequate representation. And the point here, of course, was to address very wide disparities. So on the one hand, there was a need to protect constituencies. You know, like I said, have 20,000 people. And but there was a need then to achieve the equality of the vote principle in Article 81, Sub-Article D, I believe it is, that there should be equality of the vote. You know, constituencies that have 800,000 people, 500,000 people, 300,000 people. So those were the principles that then led to the addition of the 70 over the 290, so that you then have 360. But those 360 then do not have the position of women rep. And as I think Priscilla said, she'll be speaking to that on the question when she addresses the question of gender. So you end up with 360 directly elected first past the post members of parliament in the National Assembly. You end up with 94 senators, 1 man and 1 woman per county. The principle, again, as we agreed in 2010, as a people in Kenya, was that the Senate represents the interests of the counties and the county governments. So there is an equality principle that is applicable there. There is then, of course, the question of the 2/3. And we examined the 5, I believe there have been 5 constitutional bills that have come before Parliament to try and address the question of the 2/3. We looked into that question. We looked into the recommendations made by some of the reports I've cited here before, the mixed member representation proposals, the full, you know, just like South Africa, the proportional representation model, and various other models that were looked into. The solution was to come up with top-ups, as we do have now in the county assemblies, but for a limited period of time, because affirmative action is always limited to the next 3 elections. That's just for the National Assembly, whereafter we revert to direct first past the post competitive process for both men and women. And that's how the question of representation then was resolved, and how we ended up with the 360 and the top-up positions that I've referred to there. On account of time, allow me perhaps to move on to the next question.
I think, Council Macharia,
Yes.
if, your group has already taken about 45 minutes.
Yes.
So if you can, the principals, if they can wrap up.
Yes.
Because don't, with a lot of respect, don't load too much background
Yes.
information.
Okay.
So, because your case is very clear,
Thank you.
I think you just summarize, and you can see groups are becoming impatient
Yes.
because you are timed.
Thank you.
So try to wrap up as soon as you
I will wrap up in 3 minutes. The last 3 issues allocated to me. One was the issue of the ombudsman. As I said, you will note that the position in the bill is now not the same position you had when the report was released. This was to take into account concerns raised by Kenyans as to the independence of the judiciary. The ombudsman will be a non-voting member of the JSC and will not be capable of removing any judges, directly he or herself. And thirdly, the decisions of the ombudsman will not lead to the review of any cases that would impinge on the decisional independence of the judiciary. So the ombudsman, again, views by Kenyans on independence taken into account. Devolution, I think, I need not say too much about this. In summary, 35% from 15% increased to the county allocation. There's a question about the role of MCAs. MCAs can now be appointed as CECs. The county assemblies should have their own county assembly funds. The introduction of a ward development fund. Perhaps I can take into account this as well, the constitutionalization, to deal with the questions that Parliament has faced in court over the CDF. CDF now entrenched in the Constitution. The Senate, a recommendation, as we currently see it today, the Senate doesn't have power to oversight the expenditure of counties. It only oversights by the Constitution the revenue. So there's a proposal to amend that to include oversight over the expenditure and all the revenue that comes into the county assemblies, some proposals around gender parity in the position of the governor and the deputy governor, proposals as to the Article 43, impact assessment and monitoring in budgeting and through the presidential address as well. There are also questions about, there's been a reduction in the number of members of the SRC Salaries Review Commission from 14 to 7 to be in harmony with all of the other members. And I think those are the main pointers, but the rest, as you'll see, are set out clearly. So that's about devolution, but there's a lot more we could say, but due to time, I will pass over that. Finally, on questions of security and the police, there has been a question about the harmony of mandate between the National Police Service Commission and the Inspector General. That has now been harmonized. Again, as with the Ombudsman, again following comments and issues raised by Kenyans after the report, that was also slightly altered so that the National Police Service Commission retains its mandate, other than that the mandate of disciplining police is clearly with the IG. There's a clear mandate under the IG. The DCI introduced as the third force in the police force. And maybe to add something about the DPP, the DPP is currently of the rank of a high court. That has been, the proposal is to enhance that to the rank of a court of appeal judge and to make that an independent office to strengthen the fight against crime and corruption in this country. So in a nutshell, Mr. Chairman, allow me to wrap up my presentation at that point in time. Thank you very much.
Thank you. Mr. Chairman, we are going to take under 2 minutes. And it's clear from what we have found out from Kenyans is we need a more balanced hybrid system where we have checks and balances, but at the same time, the two arms of government can be interdependent of to each other. And also, I think it has come out very clear on the gender issue. We have to push that gender parity into the political parties in the 360, and that is one of the recommendations that we are doing. I want now to invite my co-chair to conclude, and then we can wrap it up there. Thank you very much, co-chair.
Thank you very much, Honorable Chair. The principles that are based on this document have been well put out by our experts. The only thing I want to add is that the issue of representation, the issue that was raised by the Law Society of Kenya on the delimitation, I think that issue has been addressed by Advocate Tom Masharia, that this document is only setting the number at 360, but the delimitation will be done by IEBC as required by law and the Constitution. But having said, Chair, now that the committee is doing their hearings in public, I could follow in the morning what the LSK has presented, and that I don't think those are first the views of the LSK, because, Chair, this process has been very participatory, it has been open, it has been transparent, and Kenyans were given time to exercise and participate. If you don't participate by choice, nobody can force you to choose, Mr. Chair. And lastly, we should not put personal views as views of the LSK, Chair. LSK is a respected organization in this country. Your co-chair has been a distinguished chair one time. So if your views are aligned politically to certain direction, for example, if you are aligned to Tanga,
Chair,
just say that is your personal view, Chair.
Chair,
thank you so much, Chair.
Chair, is it in order for the promoter to comment on issues of LSK when the chairman or the president of LSK is not present? He was here, and that time the promoter ought to have been here to ask those questions. It's not fair for LSK, Chair.
You see, with a lot of respect, we don't want to go rigoristic because we are not in a court of law. We are loose and we are taking all views. It is good to hear a divergent view when it is expressed. However, whatever source, right? We can't just confine and say this. I think it's in order. Any view that comes to us It's interesting because a case has been made. Let us see also a divergent view. I think carry on with a lot of respect to you. Let Mheshimiwa carry on. Carry on.
Thank you, Chair, for your
And,
protection. Chair, I'm concluding.
And it is,
I'm concluding, Chair, by saying that I urge the committee to consider this bill, Chair. And as you said, that we have to hear different views, Chair. And I'm sure what was presented here was not the views of 18,000 members of the Law Society. It was an individual view. And you know, people have different inclinations, political, as I said, Chair. And I listened to it here. I was here listening, Chair. And I think we should desist from politicizing this document in a manner that is going to make Kenyans feel,
okay.
you know, confused, Chair. So, Chair, you are a distinguished lawyer yourself. You know that the Law Society of Kenya has been reduced at the moment to a village, you know, organization kind of, by the current Chair. With those few remarks, I conclude, Chair. Thank you.
It is important. It is important before perhaps you leave. If Council Macharia could comment, the thrust of the RSK objection when they raised their objections.
A point of order, Chair.
Yeah.
My name's Honorable Malwa. The point of order, Chair, is I seek your direction. Is Honorable Junet in order to impute improper motive about the LSK? Because as a body comes here to present, it's an assumption that it was through a consultative and participatory process.
Point of order, Chair.
But for him to come and say
Point of order, Chair.
There's a
to
more
a village, you should withdraw that, Mr. Chair.
No, Chair. There's a more fundamental issue before that point of order. Is whether the Honorable Chris Wamalo can raise a point of order, not being a member of the joint committee. And secondly, not having been here when we interrogated the issue.
That is what...
I thought...
let me rule. That is...
this is Parliament. I'm a parliamentarian.
Don't worry. Don't worry. Whatever... We are saying we are a bit informal because this being an open forum, public forum, I think is not in order to introduce improper motive. The rest I accept. Junet, we are not... any member who comes here, let us not impute any other motive.
Yes.
He's come here to present views, so whether in order, whether improper or not, we want to hear everybody. Let us, otherwise people will fear coming here and say, look. But I wanted for us to save time. I have ruled on that, but on behalf of my chair, we have ruled that. But
Chair, we are
I agree with that member. Dr. Chris is not really a member of the, substantively is not. He's entitled to sit here. But because we are hearing views, let us hear from even strangers. If they put their views across, we'll hear, right? But before we wrap, I wanted Macharia to, the thrust of the RSK, or the members, the loose members, the 5 members who came, they raised objection on clause 61, that it curtails their freedom to contract. 61, I think, was it 3 or 4? Yeah, you have it, Macharia, on your fingertips. See, the one which talks about harmonizing. Is it not 61? The new clause 61. The new 61. See, yes. 61 on the bill. The new clause that is seeking to harmonize remuneration of professionals, right? They said that the thrust was that was an intrusion into their freedom of contract on their fees. Any comment? Yes.
And through Chair, I think to clarify, at page 27 of the LSK's memorandum, if you can read it there, The concern the Law Society of Kenya raised before us is that what they have an issue with is what is in the second schedule of the amendment bill that proposes to create new constituencies and, using their own words, purporting to allocate them to different counties. And they say that is an usurpation of the constitutional role of IBC. I think that's the issue they have. They say it is okay to propose a creation of 360 constituencies, but they say you cannot proceed to allocate those constituencies to particular counties. I think that's the issue that they raised before us. And they also pointed out that under Article 89, you cannot do that before you consult the affected people and all interest groups from those particular regions. I think that's the issue that was raised with, and we seek your comment on. Honorable Tiandamol.
Thank you, Chair. A comment and then two questions. First, I thank the team for the presentation, especially the fact of introducing the entire report, not just the bill, because as we understand it, that there are other considerations which are supposed to come under statutory interventions. And that leads me to my first question. Have you been able to isolate the specific statutory interventions that are required and to prioritize them, to list them in order of priority? Because I think it would be helpful to share with this committee. But the second one relates to the question asked by Co-Chair Senator Kongo Mogeni, and it's twofold. First, I invite you to look at the second schedule. This is on page 26. The one that talks of the transitional consequential clauses. If you look at subclause 1, it talks of 6 months date of this act. It refers to this act. And if you look overleaf again, subclause 4 refers to this act. If you look at 6, this act, and under 2 executive, this act. So it repeats the word this act about 4 times. Was it a mistake? Did it intend to refer to this constitution rather than this act? And if it is, what is the consequence of that mistake? That's the first part. But the second part, I think, is what Honorable Kongo Mogeni has spoken to. Yeah, thanks.
Honorable Mutai.
Thank you, Chair. I just want to ask, how do you reconcile Schedule 2, which says within 6 months from the commencement date of this act, the IEBC, subject to subsection 2, determine the boundaries of the additional 70 constituencies, with Article 89, which says that you cannot review or names of boundaries 12 months before an election? How would you reconcile that? And then secondly, I'm just asking Macharia, there was an issue raised by the chairman that in amending Article 230, you are ceding away powers to IPC, to SRC, to determine fees charged by professional bodies. What's your take on that?
Just to advise you, Honorable Mutai, that 89.4 has been suspended regarding this particular amendment on the second schedule. If you look at page 28 of the bill.
Page?
28 of the bill. Subclause 6. But Honorable Gishimu, MP for Gishugu. Then we come to Honorable Kaluma.
Thank you, through you, Chair. Let me ask the promoters, in respect of the introduction via amendment of the Constitution of the Office of the Judiciary Ombudsman. First, under the intended Articles 172A2, Parliament, the National Assembly has been left out of this process of appointment of the Ombudsman. It's only the Senate. What is the rationale of leaving one Parliament in the process? Then I'd also like to know what was the mischief that was being sought to be cured by the introduction of this office? And wouldn't it have been tidier for putting these functions to the Judicial Service Commission if they do not exist, so that we also don't like have two kind of centers of oversight of the judiciary. So that's the mischief I would like to know, because you also need to explain, and whether these functions could have fitted well within the Judicial Service Commission. Thank you.
Yes, Honorable Kaluma.
Yes, Chair, I thank you. I have two questions, one in two parts, making them three. Chair, I needed clarification on the Judiciary Ombudsman. I've heard Mr. Macharia say, Chair, that the Judiciary Ombudsman will have no power to vote. Will have no power to vote. My worry is that if you look at the provision as proposed, it does not say so. Because he said to be ex officio, but Mr. Macharia knows of the several court decisions, more so around CDF, in which the court has said ex officio necessarily does not mean you can't vote. If you intend that an ex officio member of any body will not vote, you must say so. And remember, that is the reason as to why even members of parliament were removed from being ex officio members of the CDF committee. So how do we achieve that the Judiciary Ombudsman actually does not vote as intended, and as you have said, before us now that we are at this stage? Number two, Chair, there is the issue of representation, and my questions are two. You see, if you look at Article 89 of the Constitution, the criteria are so many matters to be considered in delimitation of electoral units. A most fundamental one, Chair, is this thing called community of interest. And I want to agree with the team that the constituencies they have proposed are merited. But Chair, look at transitory areas like Nairobi City here, or these cities. Can you really just go by population alone to determine that we will be adding them from 17 to 29? So it's a critical thing for me. Because you see, those people from Homa Bay living in somewhere called Mathare or Kibra know me as their MP, not their MP in Nairobi. Would it not have been better that we think of how we send these several constituencies we are giving to Nairobi? Because I see the danger, Chair, where even Kenyatta Avenue will be a constituency. Why don't we send them to the rural where these people's original interests are? And Chair, I'm reminded of something I saw behind Reinsurance Plaza Uchumi. Some statue of a man written in the heart. My body is in Nairobi, but my heart is at home in Homa Bay. So for a transitory, considering community of interest, shouldn't we balance much more? But lastly, I said it is in two parts. How do we reconcile the schedule with the power donated to IEBC under Article 89? Chair, mine is just clarification. Otherwise, I thank this team for the good work so far done.
My co-chair had given Honorable Karuma. Honorable Karuma, I think the last phase of your question was Senator Mugeni, chair, my co-chair, had given the answer and said that there is a saving. He gave it to Mutai. There is a saving, notwithstanding.
Mike.
Yeah? No, notwithstanding the provisions of 89, there is a saving in Article, the clause 16 at page 28, right? Yeah. That answers you.
It's important that we get clarification, especially from Mr. Mashari on that question.
Let us
Because some people have argued, and Mr. Mashari, since you spoke on representation, some people have argued that to the extent that the second schedule is just in the schedule, you cannot use the schedule to amend or to amend a substantive part.
Yes.
And I think that's the essence of the question. So it's still relevant to speak to it.
Chair.
Chair.
With your permission.
Sorry. Before you respond, we have Honorable Kiai, member for Mukurweini.
Thank
Then
you.
we'll come to the Honorable member here.
Thank you, Chair. On the issue of the number of seats in the National Assembly, that is 360. In a worst case scenario, where perhaps all the MPs that are elected in the National Assembly are men, what is how do you ensure that the two-third gender rule is observed? Number two, when you say that for the governors, you must have a running mate who is a lady if you're a man, and if you're a lady, you must have a man as a running mate. Why does the same rule not apply to the presidency? Thank you.
Yes, Honorable Aden.
Yeah, Chair, my concern is on the ombudsman, judiciary ombudsman. In other democracies, we see in a country having more than one ombudsman. There is the military ombudsman, judiciary ombudsman, and so on and so forth. In this case, why do we think that one ombudsman will be able to effectively execute the duties of ombudsman for the whole country, for all the sectors?
Honorable Anthony Alwach, and I think Mashari, maybe as you respond on that issue of ombudsman,
yes,
you can look at current constitution, Article 172, sub-article C. You have not deleted that power of JSC to receive complaints against judges, to investigate and remove from office. So you have created two bodies with similar mandates, because the same mandate is repeated in the proposed amendment, Article 172, 3A, where you have again said the ombudsman will receive and conduct inquiries against judges, registrars, and the likes. So you have created two parallel bodies with similar mandates. So you should look at those two clauses which are conflicting. Yes, Honorable Anthony Alwach.
Thank you, Chair, and I thank the team for finding time to come here today. Now, Chair, because this document, after this, will then be committed to the people, this is the opportunity for this team, I think, to dispel a number of misconceptions, and I have two particularly that I would like to ask that you deal with. One is the question that, the amendments proposed in respect of the legislature will lead to an over-bloated parliament. How specifically does that work out? Because these misconceptions are out there, and one particular member, I think I heard yesterday saying, this may lead to a triple, double-decker parliament. That real concern is out there. How specifically do you want to deal with that misconception for the general information of the public? And the second one is that among the things that were intended to be addressed leading to the BBI bill itself was a question of electoral mismanagement and electoral violence. And then again, there has been the misconception or the concern that this bill does not specifically in any way deal with or address questions relating to electoral mismanagement and electoral violence. So I wanted to ask that you use this opportunity to deal with those misconceptions for the public's view. Thank you.
Before we come to the friends of the committee, Honorable Senator for Nairobi Sakaja, via Zoom, you have the floor. You have really argued. You have really argued for Nairobi. We have heard you. You have made us. Thank you. Thank you, Senator. Thank you, Senator Sak. Thank you, Senator Sakaja. Now we have some amicus, friends of the committee. I think it's good that we also hear them. Honorable Gatti.
Chair, I thank you very much for this opportunity. My name is Honorable Denita Gatti. I sit in the National Assembly representing persons with disabilities. Chair, thank you because my people have been here and they have given their views, and I do hope that they will be considered. Chair, I need clarification, just a little bit, especially on the issue of gender. Chair, the Senate is clear on how, the 94. But I'm not very sure because from where we come from, or from the Mashinani, you realize that we have this kind of questions because they're asking, is this issue of opposite gender when it comes to governor and deputy, is that issue really, because in the document it says the governor shall consider, something like that, shall consider. Now, how is that? Because it's really still not very clear whether that gender aspect, especially on governor, and you've seen even governors already starting to differ, whether this gender issue, I would like to hear how this issue is going to be tackled very, very clearly if we are to really achieve this. Because, Chair, basically BBI could actually help solve this issue that we've been having on the issue of gender, the 2/3 gender. So how then do we really, what is the view? Maybe that is what the team can stress on. Maybe we can get it.
I'm sure they will clarify, Mheshimiwa. Asante sana. So I think we go back to Macharia. And Macharia, somebody has texted me saying when you published the first report, 21st of October, the schedule of constituencies was not there. It was not annexed. But it now appears on this final report of 25th November 2020. I don't know if that is correct. And the question they're asking is, did you do any hearings to determine that 28 counties were to benefit from these constituencies and leave out the others?
Thank you very much, honorable senators and members of the National Assembly. I'll group the issues that have been raised, and I think all of them concerned, but my colleagues can help me when I'm done summarizing. There are three issues I think that have been raised. The first one is about professional fees. That's Article 230. There's the question of representation, and then there's the question of the ombudsman. Permit me to begin with the ombudsman. I think it's the most straightforward one to answer. I think my learned friend and good friend as well, Mr. Gishimo, Honorable Gishimo, raised the question of vetting, why the National Assembly is not there. And then my learned friend and good friend as well, Honorable Peter Kaluma, raised the question of ex officio. I'm just summarizing this to ensure I got all the questions on the ombudsman. And then, of course, why, since the JSA can still receive complaints, is this not a duplication? And why not have an ombudsman that covers all sectors of the country? Let me begin with Honorable Gishimo's question. Now, you will recall that one of the things BBI recommends is a hybrid system in Parliament, where cabinet ministers will now be drawn from the House. And one of the big concerns raised by the judiciary and other sectors of many other stakeholders, and we all agree that we need an independent judiciary, as that word is understood in that context. Then the question, the concern raised was that you do not want a committee of the National Assembly where the executive is sitting to appear to be supervising the appointment of these ombudsmen. It was just a question raised by the judiciary itself. They wrote about it, and by many others. So that was the issue, and that is why that, and the Senate had put in a document regarding certain offices they wanted to be able to vet. And so one of the resolutions to that question was that the ombudsman should be vetted by the Senate, and that was the direct answer to that question. Now, what mischief was this office curing, and why not the JSC? Two things. We presently have a JSC member who is the ombudsman. There's actually an ombudsman as an administrative office within the judiciary. That is already there. And the question was, to use a famous Latin maxim, who guard the guards? Who will guard the guards? Who will watch the watchers? And so that you have 5 or 6 members of judicial office sitting in the JSC, you cannot have them supervising or being in charge of their own oversight on matters of complaints. That was the real issue that was being addressed here. And so when the committee, members of the committee and the experts here looked around, the model that was agreed upon finally that seemed to suit the concerns being raised here and the issues that Kenyans were raising, and we must remember, I think it bears repeating, in 2010 we had a vetting committee, or vetting board. We've had a purge before, so this is a matter that is live in Kenyans' minds as well. And so the solution recommended to the Kenyan people was to have an ombudsman who is independent of the judiciary itself, so that the judiciary is not supervising the person who is supposed to oversee complaints against them. That was the real issue that was being resolved here. Now, ex officio. The structure, Honorable Kaluma's question, the structure of the ombudsman proposed in the bill is that complaints are brought to the ombudsman processes those complaints and prosecutes them in the JSC. Now, on account of existing constitutional provisions and legal provisions on conflict of interest, they cannot be a judge over a case that they themselves are prosecuting of necessity, which is why they cannot vote. That is number one. But number two, you will see in the bill, and you'll find this at page 15, this can be clarified here to answer a question that was asked at page 15, which is the paragraph 44 of the bill. This should be a proposed new article 172A subarticle 7B, legislation to give full effect to that article. I think that also answers the question of why we can't have one ombudsman for all. It was necessary given the nature of the judiciary and the independence. We all agree it ought to be jealously protected about, that we cannot have an ombudsman for the executive and one for parliament and another one for the judiciary. The JSC can still receive complaints, yes, and that is still a carryover from something we already have right now. Kenyans have the option of going to see an ombudsman presently or going directly to the JSC. This was to give an arm's length solution to an issue Kenyans were raising and conferring this office with some real authority to hear complaints and some confidence that the complaints are being processed in a manner that responds to the issues they are raising. So that's about the ombudsman. I think those are the questions that I had. I'll now go to the question of the professional fees and the impeaching of the contractual freedom of lawyers. Number one, the article deals with professionals, not just lawyers. It really is all professionals. That is where I think I really ought to start. But number two, even as we speak, we do not have, and I say this as the lawyer who had the privilege of arguing on behalf of the Law Society of Kenya, the case that impeached a circular issued by the Attorney General regarding the same question we're dealing with here. So even as we speak, lawyers' fees are moderated currently by two bodies. Number one, Parliament. The fees, and I'm talking to lawyers because that's a question that has come, but I know other professionals also have similar arrangements. But for lawyers, being the example that was put here, fees are determined by the advocate's remuneration order to begin with. That is number one. Number two, and that must come to Parliament. It is a regulation that must be approved by Parliament. That is number one. Number two, where there are disputes involving fees, a deputy registrar of the court must still judicially determine whether those fees can be moderated or not. Article 230 and the proposal made here is in response, I think, to issues Kenyans have raised. This is a body, the SRC, that is already mandated to be doing this job. It has to consult, just like Parliament must consult when passing laws on the advocate's remuneration order. And so I think the direct answer from me would be that there's no impeachment. There is no grabbing, should I say, of the contractual right or the contractual basis upon which lawyers and their clients agree on fees. The question of representation. There are many questions here, and the first of those has to do with the role of the IBC in this issue. I think, as I said, and given the time constraints we had here, I could not take you through everything but there's a report, like I said. It's the revised preliminary report of the proposed boundaries of constituencies and wards, Volume 1, by the IBC, published on 9th February 2012. Amongst the things it contains, you will see at the back, is observations, recommendations, and conclusions they made following the first process that they undertook. That is number one. But number two, and this is to speak to the constitutional mandate they've been given to delimit boundaries and to review constituencies. The report begins by understating that they themselves at the time were constrained by the IBC Act of 2011 to use the IIBRC and JLA reports, which had stated problems, which had stated issues, which had stated concerns, which had stated recommendations, which had stated proposals that had been made the first time round. And they were required by law to use that as the reference material that they used then to come up with the constituencies that they did. That's number one. Number two, that process came with a recommendation for the 290 itself as well, which is exactly what BBI has done. BBI does not seek to interfere with the constitutional mandate of IEBC to determine where the boundary will be or will not be. All it does is give numbers. Now, those numbers are themselves suggested in the report, and the mathematical formula used to come up with those numbers is in the report itself as well. And as I say, probably time fails us now. I can't go through all of it here. There's a lot of mathematics here, but you'll see, including speaking to the question that Honorable Sakaja raised about Nairobi, and how Nairobi was dealt with in 2010, considered as a sort of special zone, and that was also set out in that report as well. So that is issue number one. Now, my good friend Kaluma, learned friend and honorable member, has talked about factors other than equality, community of interest. I think Honorable Sakaja has spoken a bit to that, to the question of Nairobi and Homa Bay. But apart from that, of course, as well, and that again is in the report and you'll be able to see, they point that in Article 89, Subarticle 7, the people of Kenya themselves, when they passed the constitution, gave direction to IBC as to the criteria in future they were to use when delimiting boundaries. And that is the same criteria that the BBI proposal repeats. And that is, of course, the question of equality of the vote, which I had spoken to earlier. And yes, of course, there's the question I'll come to, which the two-thirds question that was raised there. Over bloated parliament. I think Honorable Aloch asked that question. As I had said, perhaps I didn't spend too much time on it. In 2016, the Auditor General of Kenya examined this question. He issued a report in September of 2016 and has an entire chapter that seeks to answer the question as to whether Kenyans are overrepresented. Like I said, he went to all these countries, and I think from time to time we have all seen on social media lists of countries and other things being circulated. He actually went to those countries. And apart from that, as I said, he also consulted the International Parliamentary Union as to the average number of people within the category where Kenya lies. And the resounding answer to that question in that report was that Kenya is not overrepresented. That is number one. Number two, Article 81, Subarticle D, has principles it sets out for this country. And those are about universal suffrage and equality of the vote. So those are some of the things that had been said there. So to answer the direct question is that we do not have a bloated parliament. I will leave the question as to the configuration of the consequences. I think Honorable K asked the question about the configuration of if only men are elected. I leave it not to my colleague, Honorable Priscilla Nyokafi, because she was our gender expert, but because she's also a good legal mind on this question, and she'll be able to help us with that question as well. I should state, I think there's been a question here about electoral mismanagement and violence and how these were dealt with. Many of these issues were intertwined. Why we have violence every 5 years during elections. A good number have to do with the manner in which elections themselves are managed, but a bigger question, and this is going back all the way to 1992, 97, 2007, the Kriegler report, the Kiumi report, the Kiliku report, all of those. One of the issues raised in all those reports, and continues to be raised even with BBI, was that one of the big issues Kenyans fight over is the perception that those in leadership have, how should I say, a disproportionate role in the distribution of resources. And so the manner in which resources reach the common mwananchi is a big issue that deals with that question of our elections. But of course, I think what Honorable Oluoch had in mind was the question of the IEBC. And the report itself has a lot to say about the IEBC. It had things to say, for example, the number of commissioners. But apart from what is in the bill, because we've done a lot of legislation in this country on elections, amongst the documents that the promoters brought with them today, other than the report, is a bundle of proposed amended bills. One of them deals with elections, the Elections Act, another deals with the IEBC, and so there's a whole set of those that have been brought here, very, very many proposed amendments that deal with all of those issues. Will new constituencies create new wards? That was a matter that wasn't very pressing from what Kenyans raised. But again, and I said from the report, and you can be able to source a copy of that, or I can send a copy of that later today from the IEBC. That is a matter that IEBC still retains a mandate over. As I think you'd know, in 2010, we agreed that on average, there should be 5 wards for every constituency, but that is a matter that the bill left for the IEBC itself. Now, as to time, can this be done in 6 months? Or I think Honorable Sakaja said last time it took a year. Again, it would be helpful to look at the recommendations and some of the issues that the IEBC picked up during the last process. And they even came up with some recommendations as to some of the things that in future can help that process be less protracted, less controversial, and less time-taking. In our own estimation, based on models we used, we think the 6 months is eminently doable. There was, I'm not sure there was anything else. There was something about the timing. I think the chair helped me with that one. Yes, the answer to that one is at page 28 of the bill. The requirement of Article 89 sub Article 4 does not apply to the review. That is the one that waives the 12-month issue for this particular process. I believe I might have answered all the questions that were asked.
The only thing I've not heard from you
yes.
is whether you did wide consultations
yes.
before you arrived at this schedule of 28 counties that are benefiting from the new constituencies.
Yes, yes, yes. I was going to come to that, yes. We did extensive consultation. And when you look at the BBI report itself, and I've brought the full copy here, there is, I think, 10 or 15 pages of references, apart from the documentation, but to the people who made representations. You will recall there were town halls held all over the country. There were some of what were deemed rallies, but really were consultative meetings. So there's a lot of extensive consultation that was done on arriving at that. And I think Honorable Kaluma echoes the views of many Kenyans when he says he thinks it was merited. I think Honorable Senator Danita Gatti asked a question about the governor, the consider question. It was a delicate balance that was done here. I think it's a tortured question as to progressiveness, as to immediacy of some of these proposals. But perhaps after Honorable Priscilla Nyokafi has finished reading the very long list of positive things that women have achieved in this document, this one might begin to appear like a minor problem. So I think I will leave that one. I will leave that one at this point for many reasons. Yes, there was a question if only men are elected. I think I said I'll leave that to Priscilla to explain the permutations of the numbers as well. Male and female, why not the presidency? The presidency has some unique characteristics and provisions of the Constitution. We have a creature called the executive, created by Article 130, that says the diversity portfolio or profile of the people who should go into the executive, and you can see that in the current Constitution.
Thank you, thank you.
Thank you very much. I yield the floor.
Thank you, Councillor Macharia. And principals, we thank you for bringing in your staff to elucidate on this. It is well done. Discourse, we like, we were to hear you, Macharia, we would hear you for 2 days on this, because it's a very learned discourse. Thank you very much for your input. So, because of the time we have, time constraints, so we want to hear Council of Governors, but we thank you. We release you now so that we carry on to hear other views from other parties. Yeah, there may be need to call you or call in some of your technical staff, principals.
With your permission, there was a question, Chair, on what happens if all men are elected, because that's a very critical issue.
Yeah, Chair, with your permission, maybe Nyokavi can just sum it up in 1 minute on the issue of the gender.
Yes, Chairperson, let me just do that now with the promoters, because it was really a big question within the BBI process. And the numbers work out this way. The 360 constituencies are now coming in, where one member of parliament will represent about 132,000. The census of 2019 gives us these numbers. So now, in the 360, every party must submit a candidate's list that is 2/3 compliant. So the matter goes back to political parties. Every party must submit a list that is 2/3 compliant of candidates to start with. And we go back to the sovereign will of the people. That the sovereign will, the people are free to elect men and women, but the parties present men and women for the election. We have the extra seats coming on, the leader of official opposition, the 4 disability, 2 are women, the youth, 1 man and 1 woman, so that gives Parliament 367. The National Assembly membership is 367. The Senate is 47, which is 94 members. In terms of computation of the 2/3 gender rule, you compute with both houses. And we followed the literature of the Constitution. Indeed, our parliament is bicameral. So you look at 2/3 in the bicameral parliament and not in one house. In terms of the numbers, with 461, the 367 plus 94, you have 461 members. 461, a third, you need 153 women. We are starting with 50 already, the 47 in the Senate, the 2 women with disability, and the 1 young woman. You start with 50 already. So even at the worst case scenario, worst case, candidates have been presented, Kenyans have not elected any woman, then you need 103 women if no woman is elected in the 360. But then we don't see that happening because even now, we have 24 out of 290 women elected, which is 8.2%, with the parties required to bring women as candidates and women to be nominated only coming from those who vie. Women will now no longer be nominated if they don't vie. You have to vie first, provide Kenyans with a chance to elect more women, and only if that doesn't happen, then do we resort to nomination. If 10% of women are elected, which is 36, then you need to nominate 68 women. If 20% of women are elected with all the measures that have been put in, including resources to parties based on the number of women elected on a party ticket, then you have 73 women elected. If 73 women are elected, you really need a top-up of, in our estimation, no more than 36 women members of parliament. But worst case scenario, 103, and we don't see that happening. In any case, this is a 15-year mechanism. In 15 years, men and women must be elected within the 360 constituencies, and from there on, we will not need any further nominations. Thank you, Chairperson.
Chairman. Chairman.
Senator Mutula.
Mine is not a question, it's a technical issue, and I thought the Secretariat would think about it. The draft bills that you have submitted, if you check your date properly, is October 2020. Your bill is November 2020. It is possible that some of the recommendations here were overtaken by the draft 3. So perhaps at a later date, the Secretariat ought to submit updated legislation on this and look at the Public Audit Act, look at the IBC Act on the appointment of commissioners, which was a contentious issue in BBI 2, and it's not in 3. Look at the Public Audit Act in terms of you want the latest tabled report to be the basis for allocation of revenue, but there's no corresponding amendments in the Public Audit Amendment. So it's important that you do so. By the time we are tabling the reports, there ought to be what is a clear position on the draft amendments, including the one of the Ombudsman, is not here. Thank you.
Just quickly, Chairperson, is to confirm that indeed the bill that we are working with is the one of 25th November, and also that there are sets of bills that were drafted by the Secretariat before this process. The question that Vice Chair Otinde Amolo had asked, indeed electoral laws are urgent. If you look at the schedule of laws, in the first schedule, a lot of these drafts are actually available, and many of them respond to the questions that are raised by the constitutional bill. We had a legislative team that actually did a lot of work, and Kakai Kissinger represents that team here. So indeed, to confirm that the bills are ready, and any typos or any matters of harmonization required, those will be handled with immediate speed. Thank you, Chairperson.
So I think that should be it from the promoters for now. But in the event that the committee will require you to come and shed light on any issue, we'll come back to you. But I think for today, that should be it. Is that Senator Sakaja? Senator yes.
Why don't we just adopt that as one of the bills that is bring to effect the BBI promptly?
Okay, that's noted, Senator. Yeah, thank you. So sorry, we still have 27 groups waiting outside to be heard. We could have given you more time, but there's really pressure on us. Yeah, so you're free to leave at your own pleasure now. Thank you.
Chair, as they come. Chair. Chair, as they come. Chair.
To agree. If there are 27 groups, and given the time that we have, how are we going to handle that?
We have to...
And especially,
yes.
Secondly, there might be groups that had been invited and given some time. We also need to agree on the prioritization.
I doubt whether we can finish today, Honorable Amolo. But maybe after COG we can consult. Yeah, after we hear COG we can consult. The head of delegation should sit in the front seat. Front seat.
Let's have some order. Please, because of constraint of time, let us have some order. Please get seated. If you are with us, get seated. Enter or exit if you are not with us. Don't just start there. Either you get in or you exit. All right, karibu governor. Karibu governor, chair, Council of Governors.
Asante sana.
Yes, we are all here. We are sorry we've kept quite you and other groups waiting because the main stakeholder were here, the promoters of BBI, and we thought we should give them ample time to build a case for BBI. That's why it took us 2 hours.
On the chair.
Now, we would like to give you the shortest time possible. If you have a memo, right?
Yes.
You have played your part in the devolved units.
Or even,
So,
Chairman, I'll even give you hard copy.
Yes.
For
So just speak because we appear, we know you, we all know you. You know some of us. So the most important thing is that you put your case across within the confines of the BBI.
Thank you, Chair. Thank you. Thank you, indeed. Honorable members, I'll be very brief because there are quite a number of people waiting. Since I'm going to give my hard copy and I've already given my soft copy, I'll just summarize in a period of 2, 3, 4 minutes. Highlight. The Council of County Governors is a non-partisan organization established under the Section 19 of the Intergovernmental Relations Act. The COG comprises the governors of 47 counties, and its main functions are promotion of visionary leadership, sharing of best practices, offering corrective voices on policy issues, promote inter-county consultations, and encourage initiative formation sharing. Having said that, may I give a brief background of the support of the BBI by the counties so that we can appreciate this. We are not starting late. The council supports the national dialogue brought by the BBI initiative, which flowed from the handshake of the two principals, His Excellency the President Uhuru Kenyatta and Right Honorable Raila Odinga. The public participation in 47 counties has shown that the BBI is exceptionally popular. This is evidenced by the fact that the same was passed by a total of 43 county assemblies. Specifically, the council rounds the following proposals which would enhance delivery of services in the counties. 1, amendment of Article 202 of the Constitution to provide that where any revenue sharing is based on audited accounts and the National Assembly has not approved such accounts, the most recent audited account of revenue submitted by the Auditor General shall be used as a basis for revenue sharing. This will resolve the problem of delays created by the National Assembly sometimes in approving the county's audited reports. Sometimes the fallback can take even 3-4 years of the previous financial years. 2, amendment to Article 203 of the Constitution, which seeks to increase the percentage of funds allocated to the county government from 15% to that 5%. We will strengthen the devolution and ensure that the county governments have adequate funds to carry out their operations and development. 3, amendment of Article 204, which increases the lifespan of the equalization fund from the current 20 years to 30 years from the effective date. The additional 10 years will benefit areas currently receiving the funds, which at the moment will also be incorporated, which will also be the slums in the cities. Number 4, amendment to Article 207, which establishes a ward development fund for each ward, whereby at least 5% of all the county government's revenue, which will be stimulate development at the grassroots level throughout the country. So development at a ward level is grassroots level, and we support that. Amendment of Article 218, which mandates a control budget to authorize the withdrawal of up to 50% of the minimum amount of equitable share guaranteed to county government, while the County Allocation of Revenue Act for financial year has not been passed by Parliament. This will enable counties to receive the equitable share of revenue on time, which is, of course, at the beginning of the financial year in July, with no delay. 6, and this is the last article I'm quoting, inserting a new article, 237A, which establishes the Youth Commission to advance the participation of the youth in all our spheres of public and private life, and ensuring the mainstreaming of the youth perspectives in planning and decision making, and further advise the nation and county governments on the design, implementation, evaluation of policies and programs to secure sustainable livelihoods of the youth. This will spur economic growth amongst the youth, who are the majority of Kenya's population. The Council of Governors wishes to thank the BBI Task Force for incorporating the following proposals. Very briefly. 1, increasing the equitable share of resources to the counties. 2, establishing of one development fund, course of national and county government functions by the Commission on Revenue Allocation. Expanding of the national executive to include the Prime Minister and 2 deputies. Why are we supporting this? Because it will now create less competition at the top by incorporating more groups in the country. Creation of the position of deputy ministers. Establishment who will be serving in the National Assembly. Establishing of the leader of the official position. Very, very good addition, which we had proposed. Council is also very eager to support this process, and we are confident that the Parliament shall pass the bill in order for the counties to enjoy the salient benefits it brings along. In conclusion, then, Chairman, in view of the many benefits which will promote devolution, the Council of Governors fully support the Constitution of the Kenya Amendment Bill 2020, popularly known as BBI Bill. We therefore urge the National Assembly and the Senate to unanimously pass the bill without delay. Here, Mr. Chairman, as I said, I have 2 documents, hard copy, for the 2 houses.
Members,
with more details.
Members who have comments or questions to put to Governor. Any queries? Mheshimiwa Kaluma.
Chair of the COG, I'm very happy at the presentation. Chair, there has been something being mentioned outside there, that if 15% is not going in time, where will the 35% come from? and I'm not raising it with you as a question, but I wanted you to flag the provisions of Article 219 of the Constitution, which says revenues allocated to county shall be delivered to them without unreasonable delay. Of course, there is a challenge, but the most important thing, and without deduction. So tell your colleagues who may have misgivings on the increase that those amounts, once they are there, in as much as they may not be delivered in time, they are a debt due from national resources to those counties. I think it is an explanation you need to give to them.
It's an explanation which I accept, which I also share. May I also say that reaching the 35% should not be a major issue. It's difficult right now. Don't forget that the COVID-19 and has also caused a lot of havoc all over the world, not only in Kenya, but it is possible to raise 35%. And we have seen that it's going to be very, very possible because we have so many money being used by the national government. A good example is Kera. Those are billions. Kura, again, other billions, which if applied in the counties, will solve our problem, and also the problem of delaying the payment to the counties.
Yeah, Mr. Chair, I thank the chair of the governors. He has highlighted a lot of things and supported it very fully. But outside there is a lot of rumor about this BBI, which we have 100% supported. And the county governments being at the grassroots, being able to access the wananchi very well. Before we reach that level of yes or no, I think I will request the county governors and the county government to educate the masses outside there properly so that they exactly see the benefits that we are seeing. Thank you.
Yeah, thank you. Thank you, Chairman. My question is regarding the Ward Development Fund. Is it not true that the governors will still administer the Ward Development Fund? They'll be deciding which projects to be done in the respective wards. What role will the MCS be playing in this Ward Development Fund?
The MCAs will be playing a very, very important role, the role played by the members of parliament, of the National Assembly especially, whereby they appoint the committees, they identify the project, especially the identification of the project by the political class at the ward level, just as is done at the national level with the CDF, is very, very useful. They will be assisted by the administration to implement and also to monitor, but they will have the final word when it comes to the choice of this project.
My worry, Chair, is by virtue of the governor being the head of the county, the governor can ride roughshod over MCS and decide specifically that I want these projects in this ward, because as the law is being made progressively, the power will be vested in the governor to determine, to administer the state fund, isn't it?
Some of the counties, a few of us, like Embu, we already have the fund. We went through the law in the assembly, and we got authority from the National Treasury to do that. It's within the law. And I can assure you, our MCAs are very, very happy with the ward fund. And we don't interfere with their choices. And we support them to ensure they are well implemented, following the procurement procedures.
Thank you very much, Chair. I was listening carefully from the Chair COG. However, I had wished to hear your opinion on that particular clause, which says that for a governor shall consider running mate for the deputy. I really wanted to hear you.
Sorry, consider what?
Running mate. Deputy
Oh.
governor, yeah, as a woman,
Okay.
actually the
Okay.
opposite gender. That is one, because it's very, very critical.
You have some interest. your
But
personal
yes, I'm interested, but you have just stayed away from it. And I remember during the first bombers, it was a very controversial issue. So I really wish to hear more from you, because some of us are also aspiring to be governors in 2022. Secondly,
yes,
you mentioned about that in case it's the delay of approval of the audited accounts from the Auditor General, because normally the division of revenue is based on the recently approved. And you've said in case of the delays in Parliament approval, you will use the latest audited by the Auditor General. And I want to bring to your attention that when there is a delay actually in Parliament, it's brought from the Auditor General, not necessarily from the parliamentary level. And in this case, Parliament plays a critical role because it's the one that provides oversight. So I see that risk of maybe relying on a figure which might not be reliable and to mislead. I also wanted to hear your take on that. And lastly, Chair, when we used to have county councils, the municipal councils, the domestic revenue that was being declared was very high. But of late, the governors, by design, and we've seen in many counties, he has heavily relied on 35% that is coming from the national revenue. We've not heard anywhere in his presentation about the domestic revenue, because actually they are supposed to also contribute. And some were just doing it intentionally by design. So I wanted to hear from the COG on that particular aspect of the domestic revenue from the counties. And lastly, the issue of, at the national level, the ministers, cabinet secretaries coming from the floor of the House. And we've had many people coming up with this, that the same maybe should be applied, yes, at the county level. So I would like really to hear from him, particularly on the issue of the academic qualification, you know, because at the county assembly as we speak right now, we've not had any specific. Yeah, no, I wanted to hear, okay, let him comment as per that level, the impact or what is your take on the MCS taking over the county executive positions. I thank you.
thank you, Chair.
Yes, Senator Sakaja. We can hear you.
Thank you, Chair. First of all, allow me to congratulate Governor Wamora.
Thank you.
Becoming Chair of COG. We have a lot of confidence in him. And for the presentation. First, can I just make a comment? I think he needs to debunk this thing. Where people have been saying that counties, and I heard the woman say that counties have not been getting 15, how will they get 5? Because, Chair, the fact is, we've always given counties above 15. You know, if you look, actually, because this financial year, if you look at it as a percentage of the last audited revenue, 316.5 billion was actually 23% of the last revenue. The first year of the evolution, 226 billion was 43%. 2015-16, 259 billion was 30%, and so on and so forth. And you know, 2018-19, it was 34%, 314 billion out of 935. So it has always been done. And this 35% is not an additional, you know, money being looked for elsewhere. It is just the aligning from the 100% cake, the percentage that goes to the national government. Some of the things, if you look at, for instance, the Ministry of Health, Ministry of Agriculture, the budgets that they have for devolved functions are actually higher than the budgets of southern counties. But I just want to ask him one question, and I'm glad my good friend Honorable Wamalo has raised it, because Honorable Wamalo also is likely to be a governor in the next term, God willing. We talk so much about sharing revenue. We even had a huge fight in the Senate. But no one talks about generating revenue. We were at Commission of Revenue Allocation, we might still need a Commission of Revenue Generation. Because allocation of that intergovernmental transfer must be the third thing you look at. What is the Council of Governors thinking about in terms of enabling their counties to be more versatile? I know Chapter 12 of the Constitution limits their revenue raising capabilities. But have they put any thoughts towards that? Or are we just waiting for this at 5%, Chair? Thank you.
Thank you, Chairman. May I start with the first one? The issue of the opposite gender, governor is a lady, the deputy should be a male. We had a male, and vice versa. We had a lot of discussion on this one, and even the deputy governors brought up their case, and their chair was a lady, but we noticed that they eventually recommended that it would be very dangerous in some cases where it becomes almost impossible. But then the amendment which was done was to say may. So those are good intentions, and as much as possible they should be implemented, as much as possible. Wherever it's possible, should be done. Then the latest audited expenditure, county expenditure by the Auditor General vis-a-vis the time taken by the National Assembly. Always the National Assembly, from my experience from 2013, you drag, after the auditor has done the audit, it will take almost sometimes three or 4 years. Towards the end, it was taking 2 years. What we are saying, there should be no time lag because the Auditor General has already done his work, and if there are any issues, it will be interrogated also by the National Assembly and the Senate. It's just in order to get money in time, which is already audited, so that money is not, because sometimes the assemblies are very busy. They may not be able to cover all the county's audited reports in time. It was because of, through our experience, we are really suffering. Our money would be based, our allocation would be based on 4 years behind, and it was very little money. We could not really absorb that money, it was too little. We would absorb it, but it was really very little. Then the issue of domestic revenue. Of course, we had challenges at the beginning. I'll give an example of Embu, where 2011, 2012, the county council, the money they collected was 168 million. And we just collected almost the same amount because we had a lot to learn about the devolution. We had the wrong people. The people we recruited were not trained. They are not being inducted. And initially, the first 2-3 years, we were raising very little money, but slightly higher than the local authorities. These days, our budget, our raising of revenue, like in Nembu, is over 400 million. And we are quite happy with that, because sometimes we get our money very late and we are not able to equip the revenue bodies to buy the right gadgets, especially the softwares and all that. So in other words, now we are doing much better than the local authorities. There is no doubt about it. The issue of MCAs becoming CECs. Majority are not graduates, but graduates cannot qualify, and non-graduates will not qualify for the position of CEC. Just like an MP cannot, an MP's qualification is the same like that of a minister. No, it's not at the moment. An MP, to be a minister, has to be a graduate, executive. The CEC, the MCA to be a minister, a CEC must be a graduate. It will not be possible to get a non-graduate who is not as
Governor.
a CEC.
Okay, Governor. My colleague has a comment to make.
Thank you, Chair, Council of Governors. And what has not been answered, Senator Sakai?
I think it was about the CARA. The CARA, we have been disadvantaged a lot when it comes to receiving funds from the National Treasury. I don't know how you got those figures, Senator, where you are saying we get to do 20%, 25%. We have been doing our mathematics, and sometimes we get even below 15%, especially when our allocation is based on 3 years. If we are in 2016, and the money is based, allocation is based on 2013 or 2013-14, then of course we are not really getting justice. So most of the time we have been getting below 15%. That has been our experience. With that, 5% is real. And we have tested, we are going to test.
15% of the last audited does not have been below. I share the figures, but the point that I was actually making is that the last audited in the current constitution, that's why the last one is 2016-17. It has always been above 15% of that revenue, and I can share that with you.
Okay.
But now what India is proposing is that you won't even have to have the last audited and passed through parliament. What has been declared then is so what we're pushing for, and you guys need to stand with us on that, because our work is to defend it, is to reallocate the national budget. So we're not looking for a bigger cake to a bigger pie, but from what we have, we break down some of those budgets at the national level. But that's the point I was making. But if you look at 2020-21, this year, for instance, 316.5 billion, the last budget was 1.3 trillion, so that's 23%. So even if you don't hit 23, it's still above 15. The first year you got 226 billion, the last budget was...
Okay, Senator Sakaja, we have heard you. Thank you, Senator Sakaja, we have heard you. I think, Chair, you can't argue with Senator Sakaja on figures. The Senate is normally our mathematician, so I'm sure he's correct on those figures he's giving. But I think, as we appreciate the fact that you, as Council of Governors, you support the team, and we welcome you to Senate. But I also want to extend a special invitation to the lady behind whom you didn't introduce, called Jacqueline. She's also welcome to the Senate. No, there should not be. I'm the only one who has permission to welcome her to the Senate, and nobody else. But I just wanted to know, you are comfortable with the constituencies that have been allocated to counties, the 28 counties, and I
Yes,
hope
Chair.
your members are happy.
Chair, we are very, very happy,
Okay.
indeed.
Okay.
And it is helping the popularity of this bill.
Otherwise, thank you. Unless members, you have any burning issue, Honorable, very burning, Honorable Gatti.
It's
We
very-
have so many people waiting.
Sure, you know the governor can't go without gender. Yeah, we are talking now issues gender. But Chair, I think I want him to address, because one of the key issues that I've seen even from counties where we come from is the wastage of money that has been happening. I think you've also been seeing counties, Chair, collect a lot of money from I don't know, parking, I don't know, those, they have a lot of money they collect from so many sources, Chair, but even that money, if you look very well, I don't know how that money is spent. Now, here are governors now going to get 35%, which of course I support. I support development of grassroots. But Chair, how is the county government prepared to ensure that even within this 35%, this 5% that is allocated to ward reps, Chair, can actually be quickly disbursed to the ward reps? Because ideally, even from where we come from, we've seen ward reps who have to literally keep begging governors for something, for money to do a small thing, Christmas. I don't know, you want to do something in your ward, it is how you sing the tune of the governor. So how will you ensure that, because this is now by law, how is the county, the COG chair prepared to ensure that even if the ward rep does not support you, by law he has a 5%, he's entitled to the 5%, so that now you're not, now you see, there have been those things, Chair, which for me, I'm still thinking.
Timo Amicus, I don't think Governor Ambola will be able to anticipate what is going to happen.
Chairman, I think I'm willing. She's asking a very valid issue. Mheshimiwa is asking a very valid issue, and I can respond to it. The county-based revenue is always part and parcel of the CARA. So it must be accounted for. We have to get permission, even after we correct, from the exchequer and also from the control budget to spend it, although we are correcting it. So it's always part and parcel. And these problems will be now that it has been put into the Constitution, It will not now be at the discretion of the governor to deny the MCAs the ward fund. It will not be possible. Because that's why it is so important. That's why this bill is very, very important. At the moment, the few counties which do that, like Meru, Embu, Uasin Gishu, it is at the pressure of the governor. It will not be now. Absolutely. So it will benefit them, and they must have their akiao.
By governor.
Because of the constitution amendment.
Okay.
I'll be senator here, so I'm keen on these issues.
You'll be senator. Oh yes, I wish you well. Okay. Yeah? Okay. Governor Obola, we also extend our congratulations to you as a new chair.
Chair.
Of the
Thank you
council.
very much.
We also extend our best wishes to you.
Thank you. Thank you.
Okay, and you have put in your case very well. Yeah?
Asante sana.
Your answers were very good.
We appreciate.
Okay, thank you. You are released. Erachi, would you take 5 minutes?
Yes, Chair.
Yeah? Yes.
Yes, I will.
5
we
minutes. But because we have ODM party
Yes.
waiting, I'm saying.
Yes, we will take, Chair. Thank you so much.
If you can take 5 minutes, then we can.
Thank
deal
you,
with
Chair.
it.
Chair, we just want to thank you. And this afternoon,
Yes,
this
I'm
is a
saying
group
because this
of
woman was
women,
inside,
and I'm waiting for Otiendo.
No. Let's clear, Vice, let's clear this one.
Honorable Jlac is back to the Senate.
Thank you, Chair. I was waiting for. Yes. And we have the women coming in, Chair. This is a group of women, the Common Women Agenda, a group of women who have walked a journey with the BBI team. Honorable Chair, as women of COA, we just first of all want to welcome the move by the Honorable Members of Parliament to introduce the Constitution of Kenya Amendment Bill 2020 in the National Assembly.
Mheshimiwa Erachi,
Yes.
introduce yourself to the members. Say
Chair, you've given me 5 minutes. You know, that is why I'm trying to use.
1 minute to
but if
introduce-
you are giving me
not
time to
the
introduce.
others, introduce yourself, you as a person and the body you represent, so that it can go on record.
Okay,
and
Chair.
And then you just mention the names of your colleagues.
Thank you, Chair. Chair, good afternoon. My name's Beatrice Jlac, Cabinet's Administrative Secretary in the Ministry of Public Service and Gender. But I come in also in support of the Common Women's Agenda, which is COA, a group of women of different divergence, different professions, academicians, politicians, and women from other organizations. With me is Vivian Ta, who is part of the team, Betty Maina, part of the team, Wanja, who is also part of the team, and Priscilla Nyokabi, who is part of the team, but also who is going to present on behalf of the team chair. So, Chair, I will allow, I will just say a very brief preamble and allow Commissioner Nyokabi to present. We are humbled to be here this afternoon, Chair, as COA. COA indeed is a women organization that has been part of the process following aspirations of BBI, but ensuring and safeguarding, ring-fencing, promoting the gender gains in the Constitution of 2010 from the beginning and also at the entry point, but more importantly, seeking further opportunities for scaling up the gains through the BBI report and its implementation process in the short term, in the middle term, and long term at national and county and grassroots levels. We commend the spirit of the proposed bill and envisage that its passage will lead to the inclusivity and shared prosperities among other values and principles of women and girls. And therefore, Chair, it is my pleasure to invite Nyakabi just to present specifically the elephant in the room, the 2/3 gender.
Thank you, Chairperson and members. We will really be brief because we indeed do have a written memorandum which is very long, just tracing the journey of the 2/3. And the point we want to make today is that building gender bridges was also very, very critical. And having tried to enact the amendment bill, because the 97 now, the 2/3 gender rule way of resolving is following what the county assemblies have, the Article 177 in the county assemblies. And we would want to show in our memorandum that really there was no other moment other than this moment for the matter of 2/3 to be done. In fact, for us, part of implementing the Constitution of Kenya 2010 and the gains of women in the Constitution of Kenya 2010 must necessitate amendments to then make sure that those gains are being enjoyed by the women. It's a bit of a chicken and egg story, that for us to enjoy the gains in 2010, we must amend the 2010 Constitution to provide the formula. And this House has had several attempts at that. The other thing for us is that gender equality is now both good politics and good economics. And there are many, many studies that show that it is indeed good politics, representation of women is critical. It is indeed good economics, that participation of women in the economy. If you look at the Sustainable Development Goals, you then have better outcomes for the country when gender equality is observed. In our view, it is a constitutional imperative. We already have a sword of Damocles hanging on the House in the sense of the Chief Justice's advisory, that if the House does not give a formula, if Parliament does not give a formula, if the country does not have a formula, then Parliament is itself unconstitutional. And we don't want that happening. The only way is then to have the Constitution of Kenya Amendment Bill 2020 deal with the questions of the 2/3. We are celebrating many gains in this bill, and our memorandum shows the many gains that we have. The Commission for Revenue Allocation, the Youth Commission is equal gender representation. But we also particularly celebrate Article 43 rights: health, education, water, housing, social security, and food. Again, another matter that was put in 2010 Constitution without the resources to ensure that those particular matters are addressed. The BBI bill does give the resources now necessary to implement Article 43 rights up to the ward level. The ward fund has two functions: county functions and Article 43 rights. Now women can enjoy their rights of Article 43 at the ward level with the resources that are availed. The county funds, the CDF funds, all of those funds will go into the Article 43 matters. The Presidential State of the Nation address telling the country every year how far we have moved in terms of implementing those rights. On matters 2/3, the journey started before 2010. In fact, it is a 30-year journey. The bill now puts a stop or confirms and makes possible a 30-year journey. The CKRC, the Bomas draft, all of those had the 2/3 gender rule. And people ask, why 2/3 for Kenya? Just as we have 47 counties, just as we have homegrown solutions, just as we have negotiated matters, so do we have a negotiated minimum for gender equality. The best position is 50-50. The BBI bill brings some of the bodies to 50-50 realization, like the Senate. But the negotiated position for our country in the 2010 Constitution is a 2/3 gender rule. So the 2/3 is negotiated. It may not be possible in other countries, but just as we have 47 counties which respect our communities, just the same way then we have the 2/3 gender rule as a country and as a constitutional minimum, as a negotiated constitutional minimum that we are then now making attempts at implementing with the bill before us. Article 27, Article 10, Article 81B, all of those needing to be respected. Article 81B, captured in mandatory terms, needing therefore the electoral process to provide us with an outcome that is 2/3 gender compliant. The Attorney General had foreseen that this would be a problem in 2012 when the Constitution of Kenya 2010 passed. And he did seek an advisory from the Supreme Court. And the advisory by the Supreme Court was that it is true that the matter could be progressively realized, but then Parliament was under a duty to enact the law by 2015. Parliament extended this time by 1 year, so by 2016, Parliament then needed to enact the law. So that was the advisory of 2012. The Attorney General constituted a technical working group to implement that advisory. The technical working group was chaired by the commission that I now serve in, the National Gender and Equality Commission. It had the IEBC, it had the Office of the Registrar of Political Parties, it had the Jlac committees, Parliament, it had the Kenya Women Parliamentary Association, it had the Federation of Women Lawyers, and it had also the Commission on Administration of Justice. And our former chairperson is now the vice chair of the Jlac committee. The technical working group did look at many options of resolving this question. And our memorandum shows in detail the 10 methods that could have been used to implement the two-thirds gender rule. Some of them were extremely difficult to implement. Like, for example, the rotational seats for affirmative action, that you pick some constituencies that only elect women. There was another one of twinning constituencies. There was another one of proportional representation. There was one of reconfiguring constituencies. There was one of doubling the number of women reps that we have. And all of them were not achieving the two-thirds gender rule in full. They were making some progress, but not achieving it in full. The best possible solution for the country has become the gender top-up through party lists. But this particular gender top-up now, and we have highlighted, and you will see, Chairperson, in our memorandum, all of those methods discussed and looked at in detail. The problem with some of them is that they interfere with the sovereign will of the people. Remember, we are a country where we have universal suffrage, so we still have to allow Kenyans to directly elect their House of Representatives and their members of Parliament. So now, with the sovereign will and the two-thirds, you have two very clear goals to meet in the bill, in the BBI bill. In terms of the sovereign will, 360 seats have been created. You allow Kenyans to elect men and women to represent them. But as they elect, the two-thirds gender matter, and this is also a court decision that says the matter should be taken to political parties. There was a Katiba Institute case that judges ruled that the matter should be taken to parties. So take the matter to parties. Let the parties give us a list that is two-thirds compliant for the candidates. Put those candidates before Kenyans. If Kenyans elect men and women in the right numbers, well and good. If they do not elect the numbers required, that is when the question of top-up kicks in. The top-up is based on the votes received by each political party, so that now every vote counts. And the women who want to be nominated are also playing a part in making sure that their parties are getting as many votes as they can. The votes received concept has been introduced. Nominations have had very serious weaknesses, so now nominations are also dealt with. To nominate, you now need to first of all vie. You will not be nominated unless you first present yourself for election, you do a good run, you perform your best, and based on the votes and based on the opportunity that you had to run, that is the only list that will be used for the purposes of nomination. A lot of these matters will be further detailed by the statutory laws. We have also put that concept of the best runner-up, or what we call in our gender circles the best loser, that you tried, best loser, you tried, you are a leader, you had a manifesto, you confronted Kenyans, but given the many challenges of resources, violence has been dealt with. Violence now against women candidates is aggravated assault with even harsher penalties during the electoral season. IEBC has new duties around those matters of taking care of violence. But in terms of culture, in terms of patriarchy, we don't know whether the women will be elected. The top-up is a default mechanism. Only where women are not elected shall we then resort to nomination and shall we then resort to top-up. All of those matters are addressed. The attempts by Parliament to redress this matter from 2015 to 2018, there have been 4 bills. The 4 bills are all listed there, what we have christened as Duale 1 and Duale 2, and also what was the Chepkonga attempt. And there was also another Duale law with the current Parliament in the year 2018.
I don't want to cut you short, Nyokabi. I know you are very passionate.
Let me wind up. I could see the warning on winding up. Let me wind up. Let me wind up.
Actually 5 minutes.
Okay, sure. Okay, let me wind up, Chair. And especially the reason we are making this point is to be on record that there have been attempts. and that this attempt did not yield the results. The constitutional amendment bill now before Parliament does actually answer the question that Parliament has been trying to answer for the last 10 years. The judicial process is also documented. We have many, many cases on the matter of the 2/3, up to the advisory by the Chief Justice. Again, you will see in our memorandum the many, many cases that have been on this matter. The statement of the problem is also well articulated in our memorandum as to why we need to give full effect to this question of the 2/3 gender rule. In terms of the BBI process, the first BBI report did actually recommend that for inclusion in the 9-point agenda, then the 2/3 rule should be realized in full for the inclusion of women in our leadership. And so therefore, Chairperson, the memorandum is with you. We have looked at the clauses that relate to gender. We have highlighted all the clauses that are positive for women, and women are indeed gaining a lot with the bill that is before you. You will also find that analysis of the clause by clause and how the clauses relate to gender perspective. We are actually celebrating really what the BBI has done and asking that even questions like they shall consider in terms of governor and deputy governor, it is negotiated language. And we are happy to live with it ourselves because our campaign in 2022 will be easy. You consider the women will consider you. Any governor candidate who does not consider the women shall not be considered. Presidential candidate who wants to be considered by women should consider the women. Thank you, Chairperson.
I'm cutting you short.
Thank you, Chairperson. Thank you.
Thank you.
Thank you.
In your view, is this the best effort so far, BBI? Is it the best effort that has been made? Is it the best? Yeah,
Thank and has the support of the handshake partners. Thank you.
I will allow one or two comments.
Chair, first I want to thank Honorable Nyakabi and Honorable Jlac, and I want to confirm that I've been in those processes. I was the amicus in the 2012 case, and I was also part of the team. And the truth is, as I always said, that on this gender issue, we just had to bite the bullet. Either you implement it as now proposed, or you remove the principle. There are no two ways about it. But my question is, Honorable Nyakabi, you know, so far, the list of those to be nominated has usually been required to be with the IBC before election. Is it the understanding that now that list will only be compiled after elections, not just even nominations, but after elections, because it's to be contemplated that there might be even women who might run, you know, on either as independents or other parties. Okay. And secondly, what will be the consequence of any party that chooses to give a list of a woman who did not run?
General election. Yeah, Chairman. A quick one, a very one-line comment.
Sorry, Chair, Chair, it's a right that...
We've been sitting through, me and Kaluma.
You can't say I'm late when I've been working so hard.
To Madam Priscilla, Mheshimiwa, the proposals are good so that we don't end up in the same quarrel we have had in the past. These proposals must end up in the Elections Act, in the Political Parties Act. The drafts you have given us don't have those proposals. And therefore, we don't want to end up now, again, the two houses quarreling about the formulas. The formulas must be very specific. Thank you.
Yeah, Chair, I thank Honorable Priscilla Nyakabi and the team. Yeah, Chair, I wanted to get their view on how this provision can be sharpened. Because there is a provision that these ladies or men who are going to join the top-up will be people who have sought election. Now, it is not clear whether it is at the level of party nomination, in which case, like in my area, if you've tried in ODM and the certificate has gone to one, you are expected now to support under the law, isn't it? Or is it at election level? We want to get your views on how you clear it. Number two, there are Kenyans outside there who take the first option the vice chair of the committee gave, that instead of going the gender top-up direction, we delete this provision at once. And they argue that if you look at Article 27, sub-Article 1 to 4, together with Article 38, it establishes a first-past-the-post system. And they argue our ladies like Honorable Nyokabi are already very strong and can go and fight it out. What do you tell us to tell them outside there now that this constitutional amendment proposal will be campaigned for? I thank you, Chair.
Thank you. Just a quick one. Thank you for the presentation. Chair, mine is just to say that as we're going as a country, we tend to concentrate so much on elective position when it comes to gender issues. The ladies, the gracious ladies, should also tell us whether they've done audit on whether the government in the appointive position are complying with the gender positions, the gender issue, two-third gender issue. As it is now, we are all shifting to elective position, and we don't know whether they're interrogating the government on appointive.
Thank you, Chair. Yes, Chair, I'm a friend of this team, a serious friend. Chair, allow me to congratulate the team. I think you've seen the passion, and this really shows you have seen, Chair, you have been there, you have seen the journey that we have walked to really actualize these two-thirds. Chair, I want to hear from Commissioner Mheshimiwa Priscilla, because, Chair, as you're aware, there are quite a number of proposals on how to get the ladies, the honorable ladies, to come on board. But again, Chair, amendments have also been fronted. Several amendments are there. I don't know whether, from the Commissioner, whether if we, for example, pairing constituencies, pairing counties, pairing, there are so many things, Chair, that I really feel that Commissioner could have shed light on in terms of the kind of amendments, because we have amendments, everybody has amendments, 1, 2, 3, 4, 5, that we want to see. But, Chair, at the same time, I really want to say that Kenya is really moving with its women. And this, for me, is commendable, Chair, that we are now beginning to look at the loopholes that have existed before. And I want to hear from Commissioner, Chair, if you allow me, on what kind of amendments, for example, if we pair constituencies, or we pair, not constituencies, constituencies, what would that imply?
Any other amendments? We are saying, let's comment on what we have before us. If you ask her to bring what she desires, what is desirable, let us confine. She has said that what is before us is absolutely good for the women, what is in the BBI. If you want to comment on what the bill is all about, other than what you want to speculate on, or what you would wish outside. Yes.
I stopped there, Chair, but I'm happy with it. Thank you.
I'll rule out your question. So I'll take Shamara. I don't know whether hers is.
Thank you, Honorable Priscilla, for your presentation. My apologies for coming in late. I was just flipping through the amendment just now, the bill. I just want one thing clarified. I'm distracted because she's not looking at me. So I imagine that she's not listening, but it's okay. The question is, through the chair, is it only women who run that can be nominated? And we want this clarified because you and I know very well that there are women who are not running, who are not out there campaigning, but in the back room doing immense amount of work, and you're very aware of that. Could you seek a clarification on that?
Thank you. Thank you. Very, very quickly. Let me start with the question on the gender top-up, whether it's post-election. It is indeed post-election. It's a post-election gender top-up. So all the laws now have to be post-election gender top-up because it is a default mechanism. And it's based on votes received. So then the election must be over and votes received, and then we go to the top-up. Just on the question around the whether only those who vied shall be the ones that are nominated. This is the language of the provision. Shall comprise of candidates who stood for election under Clause 1A, which is the 360 seats, with precedence being given to those who received the greatest number of votes. It does appear, and that was really the move, because IEBC has done a lot of tests and shows that men vie about 15,000 men. 1,000 men are elected. 1,000 women vie, and about 14% are elected. So the chance of a man and a woman to be elected is almost the same, but far fewer women vie. Some counties would even want to pick a governor. Like in the gubernatorial candidate, for example, only 7 counties had a governor candidate who was female. In the senatorial. In parliament, of 290 seats, only 131 women ran. In 290 constituencies, men ran. In only 131 women ran. So now the effort must be to increase the numbers of women who vie so that we increase the chance for more women to be elected. And so what I think will be left, and I like the question by Mutula, when the laws are coming, we now have to clarify a lot of those, because it says precedence shall be given. But it's not just precedence, it shall be given, but then there could be other reasons, and we can't go into that, percentages maybe. But the first instance is to increase the numbers of women who vie. Even for the women who support parties, I think now there's only one route. Support the party as you vie. Support the party to get more votes. Support the party as you vie. And party nomination vis-a-vis the final election, again, that has become a matter of statute clarification, because at party primary level, there can also be very robust competition, especially in stronghold areas. And so that is a matter that we are hoping the statute law will also come and clarify. On the question of first past the post by Kaluma, it is true that we can have first past the post, but remember in Article 10, our national values, gender equality is a national value. And in a country so patriarchal, even for ourselves, sometimes we look very strong, but we are not as strong for our cultures. It is really, really not easy. And especially women, you don't know whether to run where you are married or where you are born. By the time you make a decision, by the time, if you vie this way, you are a foreigner, this way, you're not a foreigner. So it's very, very complex for women in a cultural setup like the one we have. And that is why, because of challenging this culture, we have 15 years of dealing with these cultural norms. Homa Bay is already doing very well, even without the BBI bill, but many other counties are not on that record. So it is double front. Confront culture. Gender equality is an imperative for the country. So there is no other way. If women are not elected, then they are nominated. Lastly, on the double-decker parliament, if women are not elected, and you have 0 women elected in both houses, in the National Assembly, and only 47 in the Senate, then you need to nominate 67 women if 10% are elected. If 20% are elected, you need 40. So in our estimation, the nomination is between 67 and 40 women. And we don't see a double-decker in that, for as long as we also need the voice of women in both houses. In the Senate, covered only National Assembly.
If you're allowed to go on, you'll convert everybody to be a lady here.
Thank you, Chairperson.
Yeah, okay, you are released. And thank you very
Chair.
much for your comments and your presentation. Give us the memorandum. Your cabinet now, we have had you. You have had the 3 widows today. And Rach, you came and come to here. You blackmailed us to hear you. There is a group waiting there, and they have been patient.
Thank you so much, Chair,
thank
and
you
we
for
are really
protecting
grateful.
us. I was already becoming female.
Yeah, everybody will become a woman here.
Yeah.
He's trying to convert us. Yes, then we hear the market. Yeah. Who is representing the ODM? Who is secretary? Where? Come forward here, Sfuna. And Secretary General.
We have about 20.
Please get seated, settle down. Professor, you are part of this? Yeah? You are part of... yeah? Secretary, don't sit together because of the distancing. The lady has to move. We have to separate you because of the distance, or go a bit. Yes. So, sorry to keep you waiting. You can see the load of presentations that is before us. So it's not our wish to keep you. But Karibu hear you, bearing in mind that the principal, one of the principals come from your party. So you are authors of this bill. In a way, you are the authors of this bill. So unless there can't be two ways, you have come to support it. Yes.
That would be correct, Mr. Chairman.
So you can now, we have heard you, then you can go. You are supporting.
Thank you very much, Mr. Chairman.
Make brief comments.
Yes, we appreciate that
a few minutes.
This committee is undertaking an onerous national task, and we are happy to wait. Just very quickly, Mr. Chairman. Very quickly, Mr. Chairman, for the record, my name is Edwin Sifuna, Secretary General of the ODM Party. I am here with Ms. Beth Siengo, who's on my left. She's the President of the ODM Women League, and the Executive Director, Mr. Oduoro Ngwen. We also have members of the party's legal committee, led by Jackson Awele and Ms. Barbara Maloa.
Okay, welcome.
And finally by Professor Sihanya, who's also part of the legal team.
We realize that is part of you.
Yes, okay. Mr. Chairman, we have gone forward and reduced our presentation into an 8-page memorandum. So we will run through it very quickly. If you allow me, I'll just proceed. And then I will let, at certain points, my colleagues to also say something to read part of the document. Yes, thank you very much, Mr. Chairman. I believe we will use 3 minutes each and proceed. Okay. Mr. Chairman, the ODM party appreciates this opportunity to make presentations on the content of the Constitution of Kenya Amendment Bill 2020. As a party, you are aware, and the chair has made reference to this, that we have engaged with this process right from the inception, and are very pleased that today we appear before this honorable committee of the Houses of Parliament to discuss what are essentially fruits of our collective labor as believers in the unity of this country. We do not take it for granted that the process has reached here, given the many obstacles erected in its path by those who did not want to see the country unite. This memorandum, Mr. Chair, reinforces the views and wishes of the members of the ODM party that they have expressed in various fora over the past 3 years. We understood from the onset as a party that this was a consultative give and take, and that no single person or entity, including ODM, could get everything that they wanted. We have studied the bill and are satisfied that it counts as a step forward, and that should the recommendations contained therein be faithfully implemented, it will lead to a united, socially and economically inclusive and prosperous Kenya. Mr. Chairman, we are happy to note that the Constitution of Kenya Amendment Bill 2020 has addressed the issue of shared prosperity, strengthening devolution, gender parity and inclusivity in development, among other areas. We have highlighted the following provisions of the bill which we believe will help achieve these goals. Number 1, Mr. Chairman, it's clause 2 introducing a new Article 10A, which provides that the Constitution embraces regional and continental integration as integral in attaining sustainable development and prosperity for all Kenyans. It is expected that Kenya as a country within the community of nations cannot develop on its own without working with her neighbors within the region. Clause 3, which introduces a new Article 11A, which proposes an economic system that enhances productivity and provides equitable opportunities for all Kenyans. By providing an economic model that is premised on productivity, fair allocation and sharing of national resources, it will in turn promote inclusive development. I will now allow Madam Beth Siengo to read from page 3 and page 4, and she has the 3 minutes that Chair graciously gave each one of us. Thank you very much.
Thank you, Mr. Chairman. My name is Beth Siengo, the ODM Women League President, and I'll take the clauses as the SG has indicated. Clause 4, introducing a new Article 118A, responsibilities of citizens. We would see that this clause will ensure responsible citizenship, will instill ethos, virtues of honesty, integrity, hard work, patriotism as key ingredients for the national development. Article 6, Amendment Article 80, Leadership and Integrity. This will enhance accountability and reduces corruption and impunity in the public and private sector. Article 11, amending Article 90, special seats in national and county assemblies. This will ensure new formula will help address the question of winner takes it all and will promote inclusivity and legislative organs. Clause 13, amending Article 94, membership of the National Assembly. It will enhance representation in areas that have been underrepresented and address equity in the representation of women, youth, and PWDs. This, Mr. Chairman, is very, very key because we know that to attain to that gender rule has been elusive. If this amendment is done and encouraged, women will take leadership because there are opportunities to increase the numbers. Thank you.
Yes, Mr. Chairman, we will just highlight a few more clauses and we will close. I want to invite the Executive Director to take the clauses from page 4 to page 5.
Yeah, thank you, Mr. Chairman. I think since this is very well elucidated in the memorandum, I just want to make emphasis on one thing.
Also part of the ownership.
Pardon?
You yourself, you are part of the ownership.
Yeah. Yes.
So I think you don't have to repeat what.
Yes. So I just wanted to emphasize 3 things about our current constitution, which is a very progressive constitution. While every article in that constitution is important, we as ODM single out 3 areas that are key to our ideological position as a social democratic party. One of them is Article 43. The second one is the chapter on devolution. And the third one is leadership and integrity. While the Constitution provides for implementation, progressive implementation of Article 43, currently there's no mechanism for the realization of that article. And the amendments propose very concrete steps to implement this, both at national and county levels. The second one, devolution, although very popular, again, there has been lack of resources to be able to effectively carry out those functions. Again, the amendments deepen devolution, and therefore, as a party of devolution, we have no qualms but to support the proposals that are there. The third one, we have this cancer of corruption in this country. And everybody has been crying that the existing framework does not effectively deal with corruption. Again, in the Constitution of Kenya Amendment Bill 2020, at least there are very concrete proposals for dealing with the issues of corruption cases in terms of expeditious apprehension, prosecution, and a trial of those suspected of corruption. So for that reason, Mr. Chairman, we want to recommend these amendments to Kenyans and ask the Parliament to unanimously adopt the proposed amendments. Thank you, Mr. Chairman.
Are there any two comments? I think there is no controversy in this. It's straightforward. Okay. Okay, on your way.
Thank you very much.
Okay, Spooner, on your way, if you see UDA, on the way you go. Also.
I doubt our paths will cross anywhere, but
no,
if we do, we will let them know.
Kenyans, everybody is.
Yes. We will let them know that you're looking for them, Chair. Thank you. Thank you, Chair.
Chair, have you seen how big mature parties present? Yes, no question.
Because I hear Ford, sometime I hear this, I hear Ford Kenya. So you go on record.
Yes, thank you, Chairman. I'm here representing Ford Kenya Party. Ford Kenya Party, Mr. Chairman, is the second oldest party in this country, second to KANU. It fought for multi-party democracy in this country, Mr. Chairman, and we are social democrats. Without much ado, I just want to say Ford Kenya as a party, my party leader, who is Moses Masika Wetangula, he appended his signature when we were in Bomas. And this is to confirm that as a party, we support the BBI. However, Mr. Chairman, there were some of the critical issues that as a party we thought we should be able to point out. One, when it comes to matters of devolution, particularly advancement of grassroots development, the World Development Fund, the 5% that comes from the county revenue, we do support that. It's keen in terms of it's going to spur development at the grassroots level. Secondly, on the issue of the 70 constituencies. 70 constituencies for purposes of equity, we do support. But now, when it comes to delimitation, this is the role of IBC. So as a party, it's our wish that we leave the mandate to the IBC to be able to do the issue of delimitation. And I was happy to note, because the issue of the 12 months, I think from this referendum bill, we have a transition clause, I think, which exempt that. And that makes us to support that fully. On the issue of the women, we do support what Honorable Jlac had said, the Coalition of Women Association. But we only differ when it comes to giving out the nomination lists. Because what is generally what we propose, to be done, is top up, which is done like in Article 177 in the county assemblies. And we know very well, as currently it is actually pre. So we can borrow the same framework, because when we go post, because even if you are a lady and you've gone for this seat, you are going there because you want to win. You cannot be able to go and run, and at the same time, you are named to be on the nomination list. So let's follow the same framework that we borrow from Article 177, the way we were handling with the county assemblies. We do support the 35% revenue. This will make more development. I know there are many doubting Thomases talking about the issue of if we are unable to raise 15%, how will we manage the 35%? That will be handled when that time comes. We had really wished on the issue of the political parties fund, and as a party, it's been a big issue. But unfortunately, we presented this before, but unfortunately, when you look at this bill, there's no reference at all on the issue of the political parties fund. It is very difficult for a political party to be compliant because of the issues that are there as far as the political parties act is concerned. But when it comes to sharing fund, we've seen the big parties. They've been taking everything. And this is making the small parties to struggle. So how I wish as time go by, we'll do maybe more amendments so that the issue of political parties fund, the threshold must be able to be reduced so that the other political parties can be able to enjoy the benefit. I think I thank you, and that is all for now from Fort Kenya.
Thank you very much, Simba. We have heard you, but as you know, Honorable Amalo, we can do very little.
Sorry.
On the content of the bill. So you either support it the way it is, or
yes,
you are against.
I know, we support, but I forgot to introduce my Secretary General here.
Yes.
Honorable Millicent Abudo. She's here with me.
Yeah, and I was wondering, for the record, I don't know that you have any memorandum.
Yeah, we have.
So we can send the Secretariat to pick. Secretariat, you can pick a copy. So thank you. I don't know, is there any member who has any comment, any observation on the presentation on Ford Kenya? Since the Ford Kenya supports, I'm sure there is no Secretariat.
Yeah, we support.
Yeah, so you support, and there is concurrence from all members. So thank you, Honorable Amalwa, for your presentation. Asante sana. Next group. Next group. What's the name? What is the name of that group? Nairobi Market Traders. You iko registered kweli? Nairobi Market Traders. Honorable Kaluma, have you heard that one? Nairobi Market Traders.
Contract.
It's a big team. Now, because of the COVID regulations, we may not take all of you. Eh? Can the leader, ule kiongozi akae hapo mbele, ule atazungumza? Kiongozi aketi hapo, yule yako na memorandum. Asante sana. Pole, sasa kwa sababu ya hii shida ya COVID, wale hamtapata kiti mtasimama hapo hapo. Kwa sababu paka tufuate sheria ile inasema paka kuwe na distance. Nafikiri kuna nafasi kidogo, tupate wawili. Excuse me, we can take two more.
There is a nafasi there. They can rush quickly and sit.
We can take two.
Waingie waketi huko haraka. Na msikae pamoja.
Haya, tumalizie hapo. Hapo. Only those two. So give us two to sit here. Two.
Mzee da bere huko.
Basi tumejaa sasa. Haya, asante. Karibu sana mwenyekiti.
Mzee tafuta kiti uketi haraka. Munaelewa ni Kizungu au ni Kiswahili? Mzee, ni Kizungu au ni Kiswahili? Tuongee Kizungu au Kiswahili?
Yote, hata tusome Kizungu basi.
Kizungu?
Yeah.
Sawa sawa. All right, karibu nyote. Yeah, welcome to this committee. My name is Muturi Kigano. I am chair representing National Assembly, and my colleague Senator Mugeni representing the Senate. Yeah, we are sitting as joint committees of both houses.
Yes.
Right? To hear your views on BBI.
Thank you.
Yeah, when you make presentations, you introduce yourself.
Yeah.
Right? Give us your credentials, who you represent, whether you are registered. And then from there, right, if you have a memorandum, you present to us. And then you can point one or two areas of concern, right, within the BBI, not general.
Yeah.
Okay?
Thank you.
Sawa. My colleagues here, yeah, kutaka kuwajua kutoka pale ni Senator Mutura. Yes.
Order. Now that the group is quite big, can't we allow some of them to observe from the upper terrace?
You can go up. Yeah. Wanaweza end up. Rules, you can allow them to go up. Yeah? These people can go to speaker's gallery.
Thank you.
Yeah, they're Who? Yeah, but we will first ask these who are here, who they are. We will caucus after this, a little caucus. Then we program ourselves. Yeah? How we are going to proceed. Okay, Muzee, I wanted to introduce this group so that you feel comfortable.
Thank
that
you.
is extreme left is Senator Mutura Kirozo Jr. Then, if you allow me to introduce Karuma. Mheshimiwa Kaluma from Homa Bay. Next to him is Mutai from Brett. Brett is in Kericho. And then you have my vice chairman, Otiede Molo. He is from Rarieda. He represents Rarieda. And then here you have Honorable Kei from Ukureini, and Aden from Wajir West. Madera West, sorry, I'm sorry. And then you have Shamara nominated, right? And then Gat is a friend of the committee, and she's Mheshimiwa committee. And you have somebody else there? Okay? So that is the committee here, members of the committee. So go ahead. Go ahead.
Chairman, technology is new, but also...
Yes, there is also somebody who is contributing through Zoom, virtual, through the, Mutada. Anaitwa Sakaja. Sakaja is your senator. Senator for Nairobi.
Okay.
You can't see him now.
Can't see him now.
Yes, but you know him.
I know him.
Yes, Sakaja is also here with us. Yes.
No, Mheshimiwa, I want to thank you, and I want to thank you, all of you. Before I move to this one, my name is I'm Professor Nathan Kahara, the former mayor of this city of Nairobi. I have the honor to serve as president of Former Mayors International here and other parts of the world. I'm also the patron of former councillors in this country. And we have added even former MCAs. Since my team is also big, as you have said, and we want to thank you because it's a team of elders, if you allow, we have, if you agree, the only one we had, Honorable Joe Akech, the Secretary General, has not come. He wasn't feeling well. But we have Councillor Christopher Anyala, the president of, the chairman of all councillors association. We have Kaberia here, the Secretary General of former councillors. Mayor John Waweru of Thika, who is also the treasurer, is also here. Abubakar Salat from the Tana River. All these represent provinces. Joshua Reparachau, who was one time the chairman of Kerio Valley Development Authority and NGO Coordination Board. Jero Francis Baka from Embu, who is the chairman of councillors in Embu. We have councillors Ogutu, the chairman of Kisumu County. And we have the chairman of Kiambu councillors, who is also in charge of Central Kenya, Chairman Isaac Kamunge. Okay. Councillor James Joroge, who is a former mayor of Kiambu, the former deputy mayor of Kiambu. He represents deputies. Ahmed Bath, that one has not come, is the chairman of county council in Garissa County Council and in charge of Northeastern. We have Samuel Adaga, who is in charge of Western Kenya, and a few others. I want to be very brief, Honorable, that by saying here that with the former mayors, international and Kenya former councillors association members, which include all other councillors in Kenya, wish to express our full support for the Constitution of Kenya Amendment Bill 2020. Mayors and councillors laid the foundation of the workings of cities, municipalities, and county councils as they are today. Further, mayors and councillors have extensive and long-standing networks and connections with the community, the common wananchi, and religious leaders. Some of them are here, bishops who are here, since they represented every location in this country, in Kenya. Their children and grandchildren, because these are elderly people, they are elders, they also have grandchildren who are also grown up. Also listen to them, they are voters. Among them, they are their supporters in all 47 counties. They have all representatives in all the 47 counties. We will continue supporting the Constitution of Kenya Amendment Bill 2020, the BPI process in our individual and collective capacities. We are proud and support the Constitution of Kenya Amendment Bill 2020 for the following few reasons. One is this increase of budget allocation to counties. Because we belong to counties, that 5% will certainly build Kenya. There will be a different Kenya. This creation of World Development Fund, when we were councillors, we used to benefit a lot because we were able to develop our wards. But so this 5% will go a long way in developing every corner of Kenya, even those that we have forgotten. Inclusion of members of the county assemblies as part of the executive is also very important because they are going to be part of the decision-making team. Unity of all Kenyans. Honorable, we value unity. We shall now elect patriotic national leaders like some of our neighboring countries. Wengine wanasema dugu, dada, dugu, when we are also focusing on our tribes. We want to elect national leaders in the future rather than tribal leaders. We are also happy to see a constitution that will benefit all, including our youth, our ladies, men, disabled, and the elderly. And honorables, we also appeal We are now appealing to honorable senators and honorable parliamentarians. We respect you a lot, and we appeal to you to pass this constitution amendment bill in this parliament to pave way for more funding and development at the county and ward levels. We also thank all honorable MCAs who unanimously passed resolution supporting the bill. Once again, we also thank honorable senators, honorable members of parliament, their excellencies, the governors who are also working closely with us, because you can see all these are retired leaders and they work with every leader. Governors and honorable MCAs who have continued supporting mayors and councillors, some who are even councillors, and we are together. So we want to thank all of you who are supporting councillors. Honorable members, we want to be as brief as we can because we are together, and there are many, many other benefits of this constitution. And we want to thank you. Once again, we appeal to you to approve that amendment bill. Thank you very much. Thank you very much, honorables. Thank you. Yes. As I said, I'm Professor Nathan Kahara, the former mayor of Nairobi, president of Former Mayors International, not only here, but other parts of the world. And I'm the patron of former councillors and Former Councillors Association. Yes.
Very good presentation. Yeah. We have a very brief and very candid and very good presentation. We are happy and we are honored to have you here. So I don't think there are any comments from members.
Chair, can I make a quick comment?
Yes.
Thank you very much, Your Worship, former Mayor, Professor. I just want to thank you for coming and just alert you that the matter...
It is Sakaja. That is Sakaja.
That's Sakaja, yeah. This is Sakaja.
Oh,
Professor,
that's my friend.
But it's been a while. I'll look for you later. But just alert you that your matter of the one of Nairobi for former councillors is before my committee.
Yes.
We'll be calling you soon.
Yes.
And we appreciate the contribution you will make. You make the foundation for the progression of this country. So I need you and tell all your members to feel appreciated and acknowledged. We will be in communication. Asante sana for your presentation.
Thank you. Can I comment now that our friend Honorable Sakaja, you have mentioned, we said as councillors that we are patriotic, we are going to continue serving, whether we are paid allowances or not, because we can see changes. But certainly, when people lay a foundation, a building like this, the person who laid foundation should not be forgotten. They are not asking for much, and we want to thank the senators and members of parliament who have been supporting us. Let them be fair, because so many councillors are dying, so many mayors are dying, and we have been waiting for a long time. I know the Senate also passed that one. Please do what you can. Let us help these councillors.
Thank you, sir.
Thank you. Thank you, sir. Thank you. Thank you, honorable members.
Chairman, I'm proposing that in your recommendation, other than the amount of money which the Senate passed, a formal recognition by the head of state, a formal recognition should be given to these gentlemen and women who worked so hard, and the precursor of the devolution system. One, Chris Wamalwa Mheshimiwa made a comment, and which comment is not made very often, and I'm going to make this comment since they are here and they are hearing, that these gentlemen used to collect more money than governors are collecting.
Yes.
It's strange, but we should say so. Thank you. As on source revenue, thank you.
Right, very well.
Thank you. Thank
because
you.
because of constraint of time,
Yeah.
you are released. You can stay or just leave at your own pleasure.
Thank you.
Okay.
Thank you.
Okay. Yeah. Not recognized. Not realized. So we will allow you to leave now, and we allow you to leave. Yeah.